7/2024.
7.
7.
Is there only for CD? CD for CD?
Yes. CD and FSL.
26. We're listing it on 26. CD along with FSL.
FSL. Oblige.
Along with, we're fixing it along with
A119 My lord, 1 meter, my lord, this is item number 11, is a motion, but this is a connecting matter, item number 54. So, my lord, this matter be taken along with 54, my lord.
11 plus 54.
Yes, my lord. Today's list, my lord.
Which is
May I plead your lordship? 439 application, your lordship. FIR is on page 8, your lordship.
when you filed this one?
Your lordship?
It was filed on which date?
Before vacation. Before vacation, your lordship.
Before July.
Yes.
According to IPC, your lordship.
IPC, ma'am.
Okay, before July.
Yes, your lordship.
Yes.
IPC.
What do you want to say again?
Yes, your lordship. The petitioner is a young boy, your lordship, of 22 years. Only allegation of attempt, your lordship, of snatching away a chain from a gold shop, your lordship. 33 days behind the bar, your lordship.
Why 25-1A is also there?
1
armed
one
Onset,
pistol
yes.
is recovered.
My lord, page 17, my lord, ground of arrest, my lord.
$33 days behind the bar, your lordship. Only attempt.
ground of arrest.
Yes. Grounds of
Go
arrest,
by the ground of arrest.
page 17, my lord.
Yes, I was saying. I have seen it. So, it's not simply
First offense, your lordship.
that means in first offense he was already equipped with everything. Okay. Let us follow. Yes, and we did bottom, yes.
CD on, my lord. 37, my lord.
30.
30.
30 will be 33 days.
We already 33 days, your lordship.
Then on 25/7, my lord.
অলপ ওচৰত নহয় নেকি? আজিতো অলৰেডি 1500.
25. 18/7, my lord.
Oblige, your lordship. Oblige.
May I please, Lordship, 439 application, Lordship, sir, today is 59 days, Lordship, in North Lakhimpur, PS, Lordship, the one theft is expired, Lordship.
One who is expert?
The Lordship, the one theft is, Lordship, one theft is arrested by the police and the expired in the police station. Then the public are the gathering, Lordship. In this case, I am the behind the bar of 51 days, Lordship. The other accused are already on bond bail, Lordship. 2 orders are, Lordship.
My lord, FIR is at page 12, my lord. Last person, what they have done, my lord, they are not only trying to, my lord, burn down the entire police station, my lord. They in a move, my lord, attack the police person, my lord, also, my lord, damage the police vehicles, my lord. So at this stage, my lord, without case diary, my lord.
Lordship, the one accused was arrested on 27th May, Lordship. He is already on bond bail. I am the arrested on, Lordship, the 15th May, Lordship. 24 May. No allegation against me, Lordship. I am the public, Lordship. Only arrested on the suspicion, Lordship.
Then, my lord, why he has not filed this bail application earlier, my lord, only on suspicion, there is nothing.
In the lower
against him,
court
my lord.
rejected, Lordship.
These are serious offences, my lord, not only
Lordship,
attacking police personnel, they are attempting to, my lord, to burn down the entire police station, my lord.
Other co-accused already bail, Lordship. On the length of detention considered, Lord.
was supposed to be reading from considering the length of the ground very be there.
Yes, ma'am.
Otherwise, there's specific against anyone. They have seen in CCTV cameras there were some persons they were
Yes, ma'am.
controlled on the basis
And
of that.
CCTV footage was also collected from the CCTV footage, my lord.
Yes.
Yes, those persons were identified, my
Persons
lord.
were.
Yes.
Now the person who was already done with the court, he was arrested on
On
20,
53 days today, on 24/5/24.
no, the person who was already released on bail was arrested on
27. One is 27. On it.
27/5.
And my lord, 90 days offense, my lord.
Yes, otherwise
20 days, 37.
At least just
No, I am only on ground of parity because
Yes.
Any condition?
custody is late.
And my lord, these are serious incidents, my lord. Recently, my lord, in this way, my lord, how mobs are attacking the police personnel, this type of incident continuously going on. So, my lord, this person is allowed at this stage without, my lord, going through the CD, my lord. Otherwise, my lord,
Other two
this is not only one single
was,
incident.
CD was paid, right?
Yes, my lord, after perusing the case there, you know.
It was there. After appraisal of the city, these department may be a bit different.
Yes.
Let us give you a short date for that.
On Friday, city is there. City
It is where it is lying.
City is there.
There is.
On Friday,
My lord, how can he say, my lord, CD? I myself, I am not at all aware about the CD, my lord. On 25/7.
on the vacation, on Friday, already gone well,
Friday,
no
okay,
materials against me, Lordship.
On 23/7.
About 500
Tuesday.
people gathering, Lordship.
Tuesday.
Tuesday,
Tuesday and it's week.
23/7, my lord, from
23/7.
23/7.
As per you, it is still lying here in
Yes.
our office.
Lordship, the petition party has already, Lordship, in the IU, Lordship, the IU has said that the seat is in the high, Lordship.
He already approached the IO.
Lordship.
Acha, very nice.
So in that
And
case,
he informed that here it is here.
this
Okay. That it is like it is like okay, we have just note down your submission that the CD is still in the office. So if it
Party
is
said, Lordship, that he is
there,
the
then
APR.
we are giving you on 23, then it can be collected from you.
May I please your lordship 439 application. Allegation, my lordship 376 and read with section 4 of POCSO Act, my lordship.
So a paid party Sarbanu Patul
Yes.
is the informant.
yes,
It takes steps on issuing notice to the respondent number 2, that is the informant because it is of the matter. And after we are also calling for the case back.
yes.
Obviously it will take some time because notice has to go there. So let it be after 2 weeks, otherwise it won't come back. So after 2 weeks,
After 2 weeks, my lord, on 31/7, my lord.
31 days.
31.
And one thing, he is behind the person, right?
Since my lord, 21/6/24.
21-6.
months. Yeah, okay. Not 4, I think it is rated section 6 of the book.
Yes.
Well, it's in on 31st of July, and you take steps for the response number from it, and we are calling for the case.
God bless.
May I please, Your Lordship? This is case is arising out of Your Lordship. An offence report, Your Lordship. CD was called for, Your Lordship.
I continue.
Your Lordship may kindly come to page 13. The report, Your Lordship, of the...
My Lord, may kindly peruse the case diary, my Lord. There is a preliminary report of the to the collector, my Lord, submitted by the IO. Petitioner's name is, my Lord, Digonta Neog. He was arrested on the basis of a statement of one Dindayal Chaube. Second paragraph, my Lord, that preliminary report. Based on the information from Sri Dindayal Chaube, another person named Sri Digonta Neog, aged so-and-so, son of so-and-so, was arrested with some objectionable item in his vehicle bearing number so-and-so, address so-and-so. Digonta Neog revealed that he supplies these illegal items to various places in Assam, and one illegal liquor manufacturing unit is operational in Kokrajhar. As per direction from Commissioner of Excise, Assam, team from Kamrup Metro Excise traveled to Kokrajhar along with Sri Digonta Neog on 23/6/2024 and recovered around 50,000 empty bottles, about 95,000 bottle caps, and more than 50,000 fake holograms, 6,000 mono holograms caramel, extra neutral alcohol, a steel tank used for blending, and a machine used for fixing caps on liquor bottles with the help of local excise team. Both the accused and arrested after medical examination so and so. Then my Lord will kindly see the next page, my Lord. The case diary, it started with the word case diary. Bottom of the page, my Lord. That page bottom, my Lord. 23/6/2024 dated. The case diary is open for the day. Sri Digonta Nayak has revealed that he supplies these illegal items to various places in Assam, and one illegal liquor manufacturing unit is operational in Kokrajhar. This information has been shared with the Commissioner of Excise Assam by the Superintendent of Excise. Next, my Lord, 8 a.m. One team arrived at the said location in Kokrajhar and contacted the local excise team as well as local police. We recovered around 50,000 empty bottles, about 95,000 bottle caps, more than 50,000 fake holograms, 6,000 mono hologram, so and so. Then, my Lord, may kindly turn to the next page, my Lord, 25/6/2024. It is not only that we have recovered in Kokrajhar, my Lord. 12 noon, my Lord. Sri Digonta Nayak has revealed that he is aware of another illegal liquor manufacturing unit in Meghalaya. This time it has gone to Meghalaya. 2 p.m., my Lord. After attaining permission from the Commissioner of Excise, Assam, and necessary communication with the Meghalaya Excise, a team from Kamrup Metro Excise has travelled to Meghalaya to unearth the said illegal liquor manufacturing unit. Kamrup Metro Excise team along with Meghalaya Excise has unearthed 2 illegal liquor manufacturing units in Rivoi district in Meghalaya, one fully operational. We have recovered approximately 15,000 cases of IMFL, huge amount of fake liquor bottle labels, fake holograms, so and so. These are, my Lord, discovery leading to his statements, my Lord, from his statement. So it's not that, my Lord, he is involved in a petty offence, my Lord. It's a big cartel, my Lord. They are involved in making illegal liquor. Illegal liquor has, my Lord, apparently 2 aspects, my Lord. Firstly, my Lord, it is dangerous to human consumption. 3-4 years back, my Lord, around 165 persons died in Assam for consumption of illegal liquor. Then second aspect is, my Lord, government is, my Lord, devoid of the revenue. Because excise is a major source of revenue for the government. If they, my Lord, will see the quantity, 50,000 bottles, my Lord. So this is what we could, my Lord, seize. There may be others. So this is a serious offence as regards the revenue of the government is concerned. We are denuded of that revenue because of these illegal activities. So 2 ramifications, one, my Lord, public health, second is, my Lord, government revenue.
May I please, Your Lordship? Now, Your Lordship, what has been submitted by my learned friend, Your Lordship? Your Lordship has already found, Your Lordship. First thing, Your Lordship, what has transpired from what my friend has submitted, Your Lordship, that I have been cooperating with the investigation, Your Lordship. That's for sure, Your Lordship. And the secondly, Your Lordship, as per the revelations made by me, Your Lordship, these things have been, Your Lordship, yes, Your Lordship, that some I am not the owner of those, Your Lordship. It is not their case that, Your Lordship, I am the owner of those, Your Lordship, the illegal, Your Lordship, the liquor made, Your Lordship, factories, Your Lordship. I am, Your Lordship, supplying as per their, Your Lordship, statement, Your Lordship. And in fact, Your Lordship, I have been cooperating, Your Lordship. 5 days custody have been given, and after 5 days custody, Your Lordship, now I am not in their custody, Your Lordship. Now I am, Your Lordship, in judicial custody, Your Lordship. Though my submission, Your Lordship, not on merit, Your Lordship. Merit, if Your Lordship, they have, and ultimately, Your Lordship, they have virtually completed the investigation, Your Lordship. Further custodial detention of the petitioner may not be required, Your Lordship. That's the point, Your Lordship. That's what I would like to submit before this honorable court, Your Lordship. That after, Your Lordship, getting everything from me, Your Lordship, and investigation has sufficiently progressed, further custodial detention of the petitioner when he is cooperating, Your Lordship. That transfers from what he has submitted, Your Lordship, my learned friend has submitted. Therefore, Your Lordship, further custodial detention probably may not be required, Your Lordship. Your Lordship will go through the entire CD, Your Lordship, but my humble submission would be that, Your Lordship. And second, Your Lordship, and Your Lordship, punishment is extendable to 3 years, Your Lordship. Earlier it was a bailable offence, Your Lordship. After amendment of the Act, Your Lordship, it has been made, Your Lordship, non-bailable, Your Lordship. And everything has been seized from me, Your Lordship. It is not that Your Lordship, I was arrested and everything, what is there in my possession, they have seized. I have pointed out, and that Kukurajar factory and then Rivoy factory, then, Your Lordship, there is nothing more to be revealed, Your Lordship. So custodial detention probably may not be required, Your Lordship. Secondly, Your Lordship, at the end of the day, Your Lordship will kindly see this is up to 3 years, Your Lordship. They ought to have followed, Your Lordship, the Ernest Kumar. Now, Your Lordship will find, Your Lordship, in the order, Your Lordship, page 15. Page 15 of the petition, Your Lordship. This is the order, Your Lordship. Page 16, Your Lordship. Considering the seriousness of the allegations and upon going through the reasons for arrest as well as the materials on record, including the case diagram, I have the view that the case law so-and-so has been complied with, Your Lordship. Now, Ernest Kumar is very clear, Your Lordship. If Ernest Kumar is to be followed, Your Lordship, then 41A notice will have to be, Your Lordship, given to me. No arrest, Your Lordship. Your Lordship will kindly go to the judgment, Your Lordship, 2023. Asfaq Alam. In many cases it has been reiterated, Your Lordship. In Asfaq Alam, again it was reiterated, Your Lordship. Your Lordship may kindly come to page para 14, Your Lordship. Then, Your Lordship, next page, Your Lordship. Before partying, the court would direct all the courts cease the proceeding to strictly follow the law laid down in Ernest Kumar and reiterate the direction contained thereunder as well as other directions, Your Lordship. Your Lordship got it, Your Lordship. Last but one page, Your Lordship. Before partying, the court would direct all the courts seized of the proceeding to strictly follow the law laid down in Ernest Kumar and reiterate the directions contained thereunder, as well as other directions. Then, Your Lordship, this quotation, Your Lordship, para 12, Your Lordship, last, we hasten to add that the direction aforesaid shall not only be applied to the cases under 498A IPC or Section 4 of the Dowry Prohibition Act, the case in hand, but also in such cases where offence is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether without or without fine. Now, Your Lordship, they are required to follow this, Your Lordship. But, Your Lordship, they have not followed it, Your Lordship. By virtue of, Your Lordship, violation of this, the Honorable Apex Court direction, Your Lordship, a right is already accrued to me, Your Lordship. I will not go to that extent, Your Lordship. They have arrested me, Your Lordship. I have cooperated, and in view of that, Your Lordship, probably my further custodial interrogation is not required, Your Lordship. And Your Lordship, also in view of the fact that the factories that they have unearthed, Your Lordship, in Kokorajan and Rivoi districts, Your Lordship, and Your Lordship will kindly note the language. It says that he knew about two other. He is not saying that this belongs to me, Your Lordship. He says he knew about. Therefore, Your Lordship, further custodial detention is not at all required, Your Lordship, and in view of what has been, Your Lordship, what has been laid down by the Honorable Apex Court. And secondly, Your Lordship will kindly note, Your Lordship, if Your Lordship takes up the Assam Excise Act, Your Lordship will find Section 48 says, Your Lordship, the maximum period of detention, Your Lordship, without producing the accused before the magistrate is, Your Lordship, 24 hours, Your Lordship.
Like that?
Section 48, Your Lordship. No person arrested under the provisions of this Act shall be detained in custody for a longer period than under all the circumstances of the case is reasonable. And such period shall not exceed 24 hours exclusive of the time necessary for journey from the place of arrest to place where a collector or other officer empowered under Section 42 to investigate as the case may be, and then to court of magistrate having jurisdiction to inquire and to try the case. Now, Your Lordship, if Your Lordship sees the offence report, Your Lordship, page 13, Your Lordship. Date, Your Lordship, 24/6/2024. Page 13, Your Lordship. This is the date on which he is produced, Your Lordship. Now, Your Lordship may kindly come to first paragraph, Sir, Madam, with reference to the subject cited above, I have the honor to inform you that on 22/6/2024 at about 7 p.m. on the tip of a secret information so and so. Now, Your Lordship, on 22, next page, Your Lordship will find 13A. It was further revealed that Sri Diganto Nayak was supposed to receive the items at 11:30 p.m. on the very day from Sri Dindoyal Subbe from his residence. Our team waited for Diganto Nayak to arrive and eventually caught red-handed while he is loading the objectionable item in his vehicle number so and so. On 22nd itself, he was, Your Lordship, arrested, Your Lordship. Now, therefore, Your Lordship, by not producing it in 24 hours, Your Lordship, they themselves has violated Section 48 of their Act, Your Lordship. And the arrest itself is illegal, Your Lordship. His detention beyond that period will have to be, Your Lordship, declared as an illegal detention, Your Lordship. Now, Your Lordship, these factors are there, Your Lordship. Ultimately, Your Lordship, he was arrested, produced, thoroughly interrogated, Your Lordship. He is behind bar for 22 days. He is cooperating as revealed from the case diary, Your Lordship. In that view of the matter, my humble submission, Your Lordship, to release him on bail, any conditions, Your Lordship. He will abide by that, Your Lordship. Stringent condition, Your Lordship, may impose, Your Lordship. He will abide by that, Your Lordship. He will continue to cooperate with the investigation. This is on instruction I am submitting, Your Lordship. This is my humble submission.
Just only one thing, my lord. There we have recorded his statement. My lord, may kindly, while passing the order, my lord, may kindly peruse that statement. There is a statement of two persons, my lord. It's already there in. I can put a flag mark, man. Diganto Nayak statement. But I'll just flag it, my. In fact, I had flagged it, my lord. Diganto Nayak, my lord.
Yes.
Yes. It's not only Subbe and Diganto Nayak, there are 3-4 other persons, my lord. He has named, my lord, who are yet to be arrested. My lord.
Lords,
Obliged.
deeply obliged.
They have raised 439 application, Your Lordship. He was arrested on 21/12/2023. As of today, 208 days, Your Lordship. Though the section 21C and 29 of NDPS Act has been attracted, nothing has been recovered from the constructive possession of the petitioner, nor from his vehicle. Only thing he sees his vehicle from his hotel. He was in a hotel. He's from Tripura in Huja. He came from business purpose. Based on the accused person's statement, he was being arrested from the hotel. And the High Court has made it clear in the recent Khaliluddin and another versus the Union of India. We are relying upon the apex court judgment, Tufan Singh and State of Tamil Nadu, Your Lordship. Observation was made that when only material against an accused is the statement of the co-accused, which the Tufan Singh has stated to be similar with that of the statement made before the police under section 161 CRPC, as such has no evidentiary value. And the statement of the co-accused cannot be translated into evidence at the stage of trial. Your Lordship, I have the copy of the same with me. And considering the length of detention, 208 days, Your Lordship, nothing has been recovered from the constructive position. The seizure list has been annexed here with the certified copy at page 18. Search has also been filed. It is in the trial stage.
Is what
Scan copy of LCM.
So obviously there may not be any involvement, but we have to see because 29 is there. May not be conscious position, may not be, but whether there is any constructive position. So let us call for the case diary along with case record along with.
The case number given in the
Yes, court has to then it can be given.
The short date, Your Lordship.
Then from Huja Melodon NDPS case.
About that, so that.
On 37. 30. But we file को इसको नंबर जोड़ना नहीं होगा file को नंबर तो लगेगा my lord, he has not mentioned anything about regarding the trial court case number, my lord.
Then it's difficult. Yes, what is the number? Can you say that?
Only stated that verbally stated that search sheet submitted, my lord. Search sheet number and then trial is going on. Yes, well, where from the record has to be called for, my lord.
Huh?
Where from the record has to be called for, my case
We
number.
call for.
I will provide after some time, Your Lordship.
But he has to be annexed all these, my lord.
Yes, have to annex.
It will not.
One thing. More or but after more you can find it.
Yes, additional
form of
affidavit.
additional affidavit. Those that can be brought up. Otherwise, it will be difficult. Because from where you get, because your public submission is there, this has already been started. It may be started also. Otherwise, 200 and more than 200 is there. So, but more. Okay. Tomorrow or day after tomorrow?
Tomorrow.
Tomorrow can tomorrow is 16th.
Probably tomorrow, my lord.
Tomorrow you should better take the day after tomorrow.
Day after tomorrow, my lord.
Okay.
Lordship, in the matter it has been written NDPS case number 5350 in connection with Lanka PS. It has been mentioned there.
Only that is PS case number, my lord.
No. In connection with the Lanka PS case number. It has been.
That is the Lanka PS means police case.
No, Lordship. In connection with the Lanka PS, NDPS case number 53/2024 has been mentioned there.
NDPS 53.
In the matter of Your Lordship, in the very first page.
No. Where is that?
Pending Your Lordship, that could not be.
So sometimes it happens that there in Assam, Guwahati only one special court there for NDPS. That is also not functioning. In fact, the officer is not well. In other districts, somewhere in additional are also getting NDPS matter. I mean, session judges are also dealing with NDPS matter. We have, yeah. Just yes, tomorrow you file.
Okay.
May I please, Your Lordship?
Yes.
My Lord, this is 483 BNSS Act. My Lord,
This is
another bail application. Lordship.
Substantive offence is under IPC, my lord.
My Lord, another
post
bail
proactive
application,
also
Lordship, in connection of co-accused, Lordship. In that case, Lordship, CD has been called for, and matter is fixed by tomorrow, Lordship. 16/7.
offenses are under IP.
Yes, substantive offences are under IPC, my
My
lord.
Lord.
But this application is filed under BNSS, my lord, 483. At this time, a case diary may be called for.
My Lord, another bail application, Lordship, that is coming on, Lordship, tomorrow, Lordship, 16/7, on BA number 1812/2024, in connection with the same affair, Lordship.
Already fixed for case diary.
My Lord, yes. It 1812/2024, BA. BA 1812/2024.
Okay, we're listing it tomorrow.
Tomorrow, and case diary, Lordship, in this
We'll
case.
list it tomorrow. Case diary. All fixed CD only, and the
Yes, yes.
matter is already fixed at 181.
Oblige.
May it please, Your Lordship. This is an 439 application, Your Lordship.
Yes.
439 of application, Your Lordship, and the affair is page number 11.
When you have filed this one? 17.
Yes, Lordship, affair is 11.
You have filed it on 17.
No, Lord.
Under
Yes, Lordship.
BNSS you filed.
Yes, yes, yes.
Okay, you have already filed for it. It's already there. You have not seen your petition. But saying that it's the application under section 438.
No, Lordship, I have filed this petition on 1st of July.
483.
Under application is 439 of CRPC. He is in custody, Your Lordship.
That's what I'm saying. You have in your
Yes,
application.
yes, Lordship.
it is
439, yes, Lordship. This is the
It's
typing mistake.
483.
No, Lordship.
No, you left.
No, you have already
July
filed
the
it.
application 483 under file ko gale.
Oh, yes, Lordship, yes. BNS Act.
So you have filed under 483 of BNSS. NDPS.
NDPS Act. Commercial quantity.
তুমি এটা কারেক্ট কৰিব লাগিব 439 483
486 দিয়া আছে তো?
No, he has already filed under 483.
Yes.
So item number 9 হয় জানো?
Item number 9. 483, yes, sir.
He has already filed under 483.
Oh, 483. But in my petition, my lord, it is written as 439.
No. This is the 483.
439 more petition. Item number 9. Government Singh. ঠিক আছে? Yes, ma'am. I will correct it. In my petition, she has not corrected it.
Okay, I will give you.
Okay, 483.
Yes.
483.
Yes, what I could well recall. Your
my lord.
petitioner is in behind the Barclays court.
So for NDPS Act, my lord,
102 days in custody, Your Lordship.
on 1st of August, my lord.
Case diary, Your Lordship.
Yes, that we call.
March of this.
May I please, Your Lordship? It's a 483 application, Your Lordship. Offence is under section 120B, 419 and 387 of Indian Penal Code. FIR is at page 17, relevant portion at page 20. May I read, Your Lordship? I have the honor to report that I meet a girl at survey area about 3-4 days ago. She introduced herself as some doctor from Dibrugarh. she shared her mobile number to me, which is so and so. Thereafter, occasionally, she used to call me to my mobile number and got familiar with me. On 12/6/2024, at about 4 p.m., she called me to her address and requested to have a cup of tea with her. Then I replied her that I am at office and cannot go now. She again called me at about 6 p.m. and requested me to go to her address. After completing my office work, I went to her address at Sandhya apartment at Bonful Nagar, Beltola survey, and met her. She escorted me to a room. When I and she were in the room and gossiping, Your Lordship, all of a sudden a group of persons comprising gents and ladies entered into the room and started videography. Then they demanded 3 lakhs from me. One of the gents identified himself as police officer and started writing my name, address, etc. in a notebook. One lady identified herself as police officer, but they were not agreed. Then they threatened me to harm my reputation and also damage the reputation of my family members if I fail to pay the demanded amount of rupees 3 lakhs. The person who impersonated himself as a police officer started bargaining and fixed the amount to rupees 50,000. Accordingly, I left the place and took 1 hour time to arrange the money and decided to meet in front of Hotel Royal Dikasa. After about 1.5 hours, when I come back arranging rupees 50,000 to pay to the so-called police officer, I came to know that the group of persons have been picked up by the police, Your Lordship. In anticipation of any danger, I approached Dispur police station to seek help. After coming to Dispur PS, it came to my knowledge that they are not the real police. Your Lordship, kindly peruse page 23, ground of arrest, Your Lordship. In the ground of arrest, paragraph 3, it has been said that during preliminary investigation, it is found that the accused Munmi Kumari called in the complainant and escorted him to her house, to her location. The complainant, when reached in the room of the accused Munmi Kumari, she opened her clothes and the complainant. When both of them are in compromised state, all of a sudden, pre-planned, the remaining accused persons entered into the room. Your Lordship, if you see the FIR, the version of the complainant is that when they are gossiping, but the version of the investigating officer are contradicting to the FIR, Your Lordship. And further, if Your Lordship see the ground of arrest, first paragraph, accordingly, Dispur police staff raided the scene of crime and apprehended the above mentioned accused persons red-handed, Your Lordship. Here they said that the accused persons are apprehended red-handed, but the FIR state that when the informant came back arranging rupees 50,000, he came to know that some persons were arrested. If the victim is not in the place of occurrence, how they can be apprehended red-handed, Your Lordship? There is Your Lordship, there is a suspicion of this type of offence, allegations, and the accused persons were arrested merely on suspicion, Your Lordship. She is a lady, Your Lordship, a mother of a 1.5-year-old child, breastfeeding child. She is behind the bar for 33 days, Your Lordship. Kindly consider the bail application, Your Lordship. Because it's a false allegation that FIR and the ground of arrest are contradicting to each other, Your Lordship.
These are organized crime, my lord. My lord, everything is not, encyclopedia is not the, my FIR is not the encyclopedia, my lord. Thereafter, during preliminary investigation, police has, after finding all these materials, has clearly, my lord, stated about the, although in the FIR, my lord, it is clear, stated that they were gossiping, but at that point of time, he may not write all these things, my lord, in the FIR. Later on, during preliminary investigation, police came to know, and thereafter, my lord, how they demanded money, and this is an organized crime. Thereafter, my lord, all these 6 persons entered into the room, and thereafter, my lord, took videography, and those things are also mentioned in the FIR. So how can it be said that this is a false case, my lord? Only CD will reveal, my lord, everything. So at this stage, my prayer
Lordship,
is very,
she is a mother, Lordship, 33 days behind the bar, your Lordship. And they are alleged that they are arrested red-handed.
This is from Dispur police station.
Yes, my lord.
It's from Dispur police station.
Dispur police station. And wearing police dresses, my lord, they are involved in committing this type of crime.
Because it is a Dispur police station. She is behind the bar for 33 times. She is shorted.
From 13/6/24.
Yes, about 30. Can you give a, I mean, not in the short cases, it has to come from the Dispur police
Yes,
station.
yes.
So,
Yes. From Tuesday, 23/7.
Friday, your Lordship.
which
Dispur police station, this Friday, 19, your Lordship.
23. 23, sir.
Tuesday. Your Lordship, date?
23, sir.
23.
Well, this matter may kindly taken up along with 54, madam. When
Yes, 11 with 50.
Yes.
Before is not.
So at the time of polling item number 54, madam, I will have to also vote for the scan copy.
Well,
It is a lawsuits. Lawsuits, first, the item number 13 may be taken up, lawsuit.
13.
Yes. In these item lawsuit, already white order dated 28/6, the case diary was fixed today lawsuit. But thereafter, the item number 12 was filed by my learned friend, and accordingly, the filing department listed the case for motion lawsuit. Unfortunately, this CD, even if there is CD, that cannot be listed with this case lawsuit today. So the matter may be fixed at 2 lawsuit. In the meanwhile, the learned APP may inquire whether this CD has arrived or not. Already around 17 days back, the CD was called for by MP Kalita Justice lawsuit. So due to this confusion, this CD may not be punished in the court lawsuit.
Okay, with that,
Yeah.
at 2 we have to.
At 2 lawsuit. Obliged lawsuit. CD CD May I please lawsuit? My lord, this is the second bail application lawsuit. Earlier bail application, your lawsuit was rejected after perusing the CD. That is, your lawsuit's order is at page 29. My lord, today I am behind the bar for 62 days lawsuit. My lord, page 29 is the order of your lawsuit. My lord, statutory period, except section 467 lawsuit, is 60 days. In fact, lawsuit 467 is not attracted in the present case lawsuit. On the last occasion, the lawsuit has also come to a conclusion that 467 is not attractive. My lord, may I tell lawsuit this 62 days, considering the length of detention lawsuit, all sections are 60 days mandatory period lawsuit. Can be considered lawsuit to the lawsuit where petitioner may be released on bail lawsuit. 467 is not attractive lawsuit at all. Today is 62 days. Only considering the lordship gravity of offence, your lordship has rejected. And today 62 days lordship.
is what.
The specific allegation against the present petitioner was that some money was transferred in his account and he withdrew that amount and given to the person. That was the allegation against the present petitioner. And in fact,
I will get the updated case diary, my lord, whether my lord police regarding the present status of the investigation.
Already your lordship has done.
Because my lord, your lordship has earlier rightly rejected the, after perusing the case diary, how these persons are involved in morphing the image of the other persons, and by producing fake identities they collected loan. They in fact, my lord, in this type of cases some bank officials are also involved, bank personnel are also involved, my lord, and thereafter, my lord, those persons in the name of whom, my lord, they took loan, later on they, my lord, get notices, and thereafter only they came to know that these persons in their name there are some loans in the bank. So these are serious offences going on in some recent cases. Some of the, my lord, high bank officials are also arrested in many some of the cases, my lord. Not in this case, maybe, my lord. So my updated case diary may be called for, my lord. 90 days offence, my lord. 467 is also there, my lord.
Now he's basically, his submission is most probably that he is not at 467 is not affected.
Yes, my lord.
But everything is that if money was transferred in his account through
Yes, my lord.
documents
Yes,
and
my
all.
lord. Directly in
So
his account, my
directly
lord.
cannot be said that the 467 is not
Yes,
affected.
yes.
But obviously his role was there that he used to take 20 to 30% commission and then disburse it.
Yes, ma'am.
Let us call for the
Updated case diary, ma'am.
we'll try to give you
my
a
lord,
short
already 62 days lordship behind the law.
It's
If
not
467,
offense is very serious.
my lord, yes, absolutely, lordship. If the section 467 is not attractive, lordship, obviously his lordship is entitled.
Directly cannot be said that it's not attracted because through court documents
No.
and all those things
There
are
is,
going on.
my lord,
His involvement, how far his involvement is concerned, maybe may not.
my lord, there is no allegation against the present petitioner that he has forged the document. Only his account was used, lordship. Account number was used, bank account number was used. That was the lordship specifically
It's
alleged.
updated with when you call.
On 25/7.
My lord, very long lordship.
Thursday. Then
I
on
give you a
22.
shorter than
On 22/7, then Monday.
call for update. Update.
Published.
May I please, Lord?
Yes.
Say a regular bail application lordship under 483. This petitioner lordship was arrested on 23/5 lordship. It's a 60 days offence lordship. He is already behind the bar for last 54 days lordship. This FIR lordship is of the year 2019 lordship. This petitioner, he hails from Meghalaya lordship. On 23/5 lordship, he came from Shillong lordship by driving a Bolero lordship, which was not having number plate lordship. Then he was at the check post lordship, this STF stopped the vehicle, and subsequently, because the vehicle was not having the number plate lordship, so they arrested him on suspicion that the vehicle was a stolen vehicle and implicated him in this case. And subsequently, lordship, is that from him some documents were seized as per the forwarding report lordship. So, but the original owner of the vehicle lordship, she has filed a Jimma petition before the CGM lordship. She says that he is his neighbor, and on that they entrusted him with the vehicle to come to Guwahati to purchase some accessories for the vehicle lordship. So this person lordship, they are Khasi people lordship, they came without the number plate. But there was number plate, he did not put. It was applied and it was there, but they did not put that number plate. That lordship, that Jimma petition is pending, and the owner has already filed an affidavit also. That is Annexus 7 lordship at page 21. And all the documents I have annexed lordship. She says that it's not a stolen vehicle, and she is the registered owner. And she has also given her documents, which we have annexed here, and some orders from the Jimma petition is also annexed, Lordship. So as on today, Lordship, 54 days, Lordship. It's a 60 days offence. Considering the length of detention, Lordship, only my prayer would be at this stage. And the case is of 2019, Lordship.
Why 468 or 471 is not?
I don't know, some documents were seized from that earlier. It was registered in 2019, Lordship. Way back in 2019. If Lordship comes to the FIR, Lordship, at page 12, Lordship. From those persons, Lordship, some false documents were found, I think. One Ashish, Devnath, and Ajay Ghosh. And they are already released on bail, Lordship, way back. And this petitioner, Lordship, he deals in second-hand car also, Lordship. He does the business. And through OLX, he came in acquainted with this Ajay Ghosh, Lordship, who was arrested there. So some documents were with him also. So he was arrested. As on today, 54 days left. Already 5 days police custody was also given.
Yes.
Although my lord, case was registered in the year 2019, my lord, but these accused persons are running away, fleeing from justice. Now police has arrested them, my lord. And my lord, it is specifically mentioned that these are the gang of, my lord, interstate bike lifters, vehicle lifters, my lord. So now, my lord, thereafter, initially police arrested in the year 2019 two accused persons, and because they are fleeing from, running away from police, so now police has arrested them. So my lord, only case diary will reveal, my lord, how these persons are.
Is it a case of 60 days of?
FIR is of 2019, my lord.
No, 60 days offence.
Yes.
Yes.
Is it a 60 days offence? 471 is offence. 471 is 60 days?
471 is bailable also.
468?
60 days
468 is 67 years.
60 days of
7. 60 days.
Suppose if it's the 60 days offence, he is behind the work for...
So then I will get the
54 days.
I will get the instruction, my lord. I have to, my lord.
Because if
whether search sheet file or
investigation
not.
is still under progress, suppose within 4
Yes.
5 days, if it is not possible, then it's okay. Otherwise,
Have to, my
we
lord.
can
I will-
start at 2 here.
Yes.
Medical. 439 application. Now is not 439. Regular bail application. He is arrested on the 22/6, 24 days in custody. Lordship will find the affair case 14, my lord. Lordship has dealt with the case, my lord, in 2 cases, my lord, not looking for PS case number 141. Following a death of person in police custody, a mob attacked the police station by pelting stone, my lord.
So, if one thing,
Yes, my lord.
same, if it is
Yes,
the
my
same
lord.
case,
Yes, my lord.
on it just read item number,
Today's my lord.
today's list, yeah. The dot pro. Let's take it out. 20. Oh no, item number 4. Item number
4, I think.
Item number 4. Huh? Okay, right. Do you have with you item number 4?
141,
Item number 4.
Yes, my lord, on section 23(7).
Same police station, no?
My
Not
lord,
same.
141.
One case pertaining to the same police station is fixed on 18th, my lord. 18/7.
18/7.
18/7, my lord. I have the order, my lord. In fact, 2 cases, one AB, one BA. On 18th.
18th.
On 26 my lord, 4 person has been granted bail by this.
Along with the other case
Yes,
number?
yes. BA number 1776 of 2024.
Along with BA1?
1776. 24. 20.
Another one? AB?
AB 1669. 24. Yes.
18 or no?
18.
No, then
18.
Double.
Maybe in this case, we have come for posting of FIR on the ground that the victim has given his affidavit as page 25, 24 and 25. So I stated that the case was false. So, my lord, at this stage, notice may go, my lord. Affidavit, your lordship, starts from page 24, my lord, next 3.
Scan copy should come and notice may go.
Notice may go.
That's it.
Number 20 to 24. No problem. But number 1 and as per your instruction, is the case that the case of
Appearance, madam. Appearance before the court. We are not paying for stay, madam.
After or after
After 3 weeks, in the meantime, scan copy may become.
calling for this time. Therefore, it's recorded. It's done. Chief.
Available.
My lord, two brothers have some quarrel regarding some plot of land between the two. Lordship may kindly see page 19, my lord. Here, complainant is Najima Begum Borvuya, page 19, left side. And accused is Hamidul Borvuya. These are two brothers and sister. Now, Lordship, in this case, my lord, the police came to the spot for arresting Hamidul, that the present petitioner. It is alleged that at that time some unruly mob tried to attack the police person. And taking that advantage, Hamidul Islam Borvia has evaded arrest. Now, kindly see the FIR which has been filed by police. Let me go through the FIR. Kindly see page 11, my lord. Page 11. With reference to the subject cited above, I beg to report that today at 7:30 p.m. I, along with SI Onkur Soikia, UBC 942 Rohimuddin Khan, WBC 358 Shanta Tati, H.G. Rohimuddin Borvia, so-and-so, personal when to the house of accused person Hamidul Islam Borvia. This is a present petitioner of Goshaipur Part 3 with a view to arrest him in connection with UDB PS case number so-and-so under section so-and-so. While I, along with the available staffs, arrived at the house and premises of the said accused person, as per procedure, the unruly mob led by Nazrul Islam Borvia gathered with 40-50 persons, attacked and obstructed our government duty and used slang words with dire consequence to the police personnel. The accused person Hamidul Islam, this is very important. The accused person Hamidul Islam Borvia is able to fled away from the spot with the help of alleged person noted below. So, my lord, they went to arrest Hamidul Islam Borvia. Unruly mob gathered there. They obstructed the police, and during this time, this Hamidul Islam Borvia fled away. Now, what offense he has done? If he was arrested, then he has gone away from the custody of the government officer. Then he has committed an offense. He could not be arrested. There was unruly mob, altercations of words. So, my lord, taking this advantage, he fled away. But police could not arrest him. Had the police could arrest him, then he fled away, then that is an offense. Here is not that. Similarly, my lord, in the same case, my lord, another person, my lord, can you see? So, that was another person, the headmaster, who went there to see the incident and pacify the mob. He was also mad. His name is J.M. Iftikhar Ahmed Lashkar, but he has been Hussein Ahmed Lashkar. Whatever police does, that case has been stayed by this Honorable High Court. Because he is a headmaster of a school, and his name is totally different of the name of the enlisted accused person. That is Hussein Ahmed Borvia. He is J.M. Iftikhar Ahmed Lashkar. So here, Hamidul Islam, my lord, he has committed no crime at all. Naturally, police will come. Nobody will stand by that he has let me arrest by police. But if after arrest he flees away, then there is a crime. Here is not that case. So my limited prayer is this, my lord. Till the record may kindly be called for, and till this, so far the proceeding against this particular person is concerned, may kindly be stated.
Can copy come, my lord, and
what offence I have done? Let my learned friend say. If he has arrested me and I fled away, then I have committed an offence.
Already charge-sheeted?
No, you are wrong today. Charge sheet was filed between the brother and sister, and thereafter, in this case, they were summoned. Police came, but police could not arrest me. For arresting a person, a concrete ground must be there. I fled away. It is natural, my lord.
Particular case is charge-sheeted or not?
Charge-sheeted case. Charge-sheeted case. But thing is this, my lord, my submission is this. Police did not arrest me. Police came to serve summon. Summon I have annexed here. Can you see? Summon, page 28. So what offence I have done?
This is Udarbhan PS case number 63 of 21. What I am wrong, my lord? It's charge-sheeted in page number 17. Charge-sheet number 76 of 21.
In the brother and sister's case, my lord, case is acquitted. Kindly see judgment, page 90.
But in the particular case, it is charge-sheeted. Where I am wrong?
Charge-sheeted, but summon was issued, and I could not be arrested. When police came, altercation took place, I fled away. So he had police arrested me, then I fled away, then I have committed an offence.
Running away from police arrest, avoiding police arrest. You want to say that you have...
No, my submission is this, my lord. Yes. No, police did not come to arrest me. Police came to me to serve summon only.
Saying that you have not committed that offense.
My lord, police came to serve summon.
Whatever, you have received someone.
But
that is a person who is supposed to be a law-abiding person that you without receiving someone. Some people were there.
But thing is this, my lord.
There and you fled away.
What will be the offence then? My only prayer is this: what offence I have done? Because police could not arrest me.
Your instinct is some other people came and obstructed the, even in serving the some.
No, I have not obstructed. There is no allegation against me. Kindly see again FIR.
Situation, in your investigation, if people came and obstructed the police, not allowed. Obviously, we'll issue notice. Let us see. But stay cannot be.
LCR may be called for.
Yes, call for. Otherwise, better was you could have someone, that's all. Also called for the. Is the charged with what?
Charged.
It's after authority cannot come after people.
So, police came to serve someone upon me.
Not after 2 weeks.
After this, he is a ASI, so PS, he is the ASI.
Oh. Who is the
Complainant.
Complainant.
Oh, complaint is there.
So
I
by
think-
name, so
I think 4 weeks would be better because notice has to go to him also.
After 3 weeks, sir?
LCR may be called for.
Yes.
Highly obliged.
Wait, please, Your Lordship. With respect to item number 19 and 20, Your Lordship, out of the same FIR, from the same family, Your Lordship, I'm praying for quashing of the FIR. At this point, I'm only praying that the notice may be issued, Your Lordship, because I've already filed an anticipatory bail application, which is item number 38. Your Lordship, may kindly take up item number 38. Today's
This
case
is
only.
the second for 20, 19 and 20.
I'm only praying a
You are
notice may be
talking about
issued,
issue.
Your Lordship, because I'm. নাই এখন নাই
নীতিশ
কুমাৰ এইটো বেলেগত আছে
Issue no. Here we are looking notice.
Yes, Your Lordship.
And apart from that, this is the
CD is required. No, it is not suspected.
not that.
Not such, Your Lordship. Your Lordship, with respect to bail, Your Lordship, may I pray?
Yes,
There
yes,
is no.
just take off.
এইকেইটা তো CD লাগিব
চেষ্টা এটা কৰিছোঁ Your Lordship, may kindly peruse the bail application, the FIR
So now item number, you are on item number.
on item number 38. Your Lordship.
19 and 20 same on
19 and 20.
Notice is to. But in this quashing petition also, CD is required.
Yes,
That's what he is saying now. Now you are on item number
38. Your Lordship.
That is B. AB.
AB.
1 3 3
38, Your Lordship. The father, the mother, the sister and the brother, Your Lordship, of the main accused.
It's a 30, it is an AB.
AB, Your Lordship.
So now yes,
May I read the FIR, Your Lordship?
FIR is the page.
FIR it starts at page 14. This was a complaint. Subsequently, it was written into an FIR. 14, Your Lordship. Not reading paragraph 1, paragraph 2, Your Lordship, that the complainant had got unfolded for accused number 1 when they met in the. Now, accused number 1 is not a petitioner in this case, Your Lordship. The complainant's liking for you got to be enlightened after you choose to warmly welcome and acknowledge the same with a liking of the same tenor for the complaint without being laid to the list with magnetically compressed the accused number 1 closer to the complainant, culminating in love and affection by and between them. Both of them took pride in having sweeter text SMS via Instagram, Facebook, etc. set at the exchange by and between the complainant and accused number 1. As a measure of love, the complainant regularly visited the stationery shop near apartment of accused on the pretext of purchasing some groceries, having come to know that the accused number 1 used to grow restless unless accused number 1 could not see the complaint. That furthering the relationship, accused number 1 used to visit the complaint to accompany accused number 1 to various parks. Now, you know, see, if I may just summarize, the allegation of the complaint is that she got married to the accused number 1. Subsequently, the accused number 1 fled away. There is no allegation against the other accused persons, Your Lordship. I may read the entire FIR, Your Lordship, once. The furthering the relationship.
Now in your petitioners are there.
I'm the father. The accused petitioner number 1 is the father, Your Lordship. Dinesh Soni. The 2 is the mother. 3 is the brother, and 4 is the sister, Your Lordship. No, absolutely no allegation against us, Your Lordship, in the FIR. I'm only praying for a protection at this stage, Your Lordship, with respect to them, Your Lordship. I'm ready to cooperate with the investigation, Your Lordship. No allegation. That is why I filed a criminal petition. Unfortunately, Your Lordship, there was a vacation, and that is why I have to move this application. And this is also listed today, Your Lordship. Absolutely no allegation, Your Lordship. I may read the entire FIR if Your Lordship wants me to. Only some protection in this, Your Lordship. May I read, Your Lordship? That furthering the petitioner number 1 used to insist the complaint to accompany accused number 1 to various parks to have some equal quality time with her. In case the complainant refused, the accused number 1 pretended to be restless. Accused number 1 also went for shopping at shopping malls such as City Centre and sharing foods at various restaurants here at Guwahati. Eating pani puri with accused number 1 at Patharkusi became a habit of the complainant, which was witnessed by many in the locality. That for being in relationship with the complainant, accused number 1 booked a room in Hotel Central Inn situated at Ganeshguri on 22 to 2023 on the pretext of celebrating his birthday party, and insists the complainant to attend the same along with other invitees. The complainant went there at 9 p.m. as per stated schedule, but only to get surprised to see that no guest arrived there till 10:30 p.m. and asked him about the reasons of the other guests not turning up. Accused number 1 assured her that they would arrive after 11 p.m. as they would celebrate the occasion for the whole night and stay together. But sadly to say that no guests turned up on that night. Rather, accused number 1 organized some rites and rituals in presence of 2 of his friends and performed marriage with her as per customary law. He also put vermilion over complainant's forehead. After the rituals being over, all of his friends departed and the accused number 1 forcefully committed sexual relation with the complainant despite strong resistance with force to the pretext that before actual social marriage. Now she admits that fact, Your Lordship. She would not let accused number 1 to have physical relationship with her, but she was compelled intimating that unless she submits to his last, accused number 1 would divorce her forever. Besides that, accused number 1 also acknowledged her saying that the complainant cannot prevent him of physical relationship as she is his wife now. After her submission to your last under compulsion, when the complainant started crying, accused number 1 convinced her that he will marry her soon formally after he gets settled with a job. Accused number 1 stated that another accused person who are his parents and siblings are also aware of the marriage with the complainant. They would accept her as their daughter-in-law very soon. That in course of time, accused number 1 took the complainant to his aforesaid swastik enclave jointly resided by the other accused persons who also warmly welcomed the complainant, which convinced the complainant that his family members were really aware of the marriage, more so when accused number 2 and 3 visited the complainant at her rental home on and off and invited the complainant to the apartment for lunch and dinner during the last 2 years. During his whole period under the guise of the said fraudulent marriage, you kept exploiting the complainant sexually on 8 to 2023, 9 to 2023. That on 4 to 2023, when you came to complainant's central room and intended to have physical relationship, the complainant refused on the pretext of unless the accused number 1 marry her formally and take her to his house as his wife. Accused number 1 got enraged about the complainant and insulted her physically. Accused number 1 also forcefully took her cell phone and deleted all text messages, online chatting and video calls recording from her mobile and went away from the place, intimating her not to contact him anymore as he abandoned the relationship with the complainant. On 10 to 2023, accused number 1 again came back and resumed relation by begging pardon for his abusive manner of 40 to 2023. In order to win the complainant's heart, he also dishonestly disclosed he is about to marry her as soon as he taken the consent of his parents for the same. Surprisingly enough, his parents also came to her and begged pardon for the misdeeds when the complainant detailed them about the said incident dated 40 to 2023. Taking advantage of the fact that the complaint was becoming normal with the accused number 1 as she was assured of formal marriage soon, all of a sudden accused number 1 entered into her room on 25 to 2023 for physical favor when the complainant denied outrightly. Getting fed up, accused number 1 went away from the room after assaulting her physically and finally he went to Bangalore to stay with his elder sister, namely Simran Soni, accused number 5, even though without informing her. That the complainant got exhausted both mentally and physically due to sudden departure of accused number 1 on the last 10/8/2023. The complainant dialed you and asks you to take her to Bangalore and keep her with you as your wife. You got too aggressive and asked her forget you. But reminding about your marriage dated 2023, when the complainant stated that she would also go to Bangalore, accused number 1 threatened her of direct consequences if she dares to meet him. That being threatened, so when complainant stated that she would have recourse to law, you shockingly stated that since accused number is under marriageable age, the complainant could do no harm legally. Unfortunately, accused number 1 never disclosed this fact to the complainant at any point of time during your relationship. Accused number 1 also blocked her contact number. Thus, accused number 1 defrauded the complainant by suppressing the fact of his age and exploited her sexually, physically, emotionally, and financially with a dishonest intention from the very beginning. That being exhausted by his avoidance, the complainant called on the other accused persons who were in rental room on 29/12/2023, but they avoided the call unattended. So the complainant went to the residence, swastik apartment, and placed all the said incident to her flattering before accused number 2 to 4, but it has to be no avail as all accused conspired against their complainant and abandoned her on the pretext of minority of accused number 1. Having heard about calling of accused number 2 and 3 to her room and insisting for marriage, accused number 1 came to her room on 28/12/2023 after returning from Bangalore and assaulted her physically. Accused number 1 forcefully picked up her mobile phone, deleted all proof of relationship with him, and left the room, threatening her not to meet him again. Then when the complainant contacted you via other phones, she is being abused by accused number 1 with slang languages and intimidated her with criminal consequences if she dials him for any other number. He even threatened her at gunpoint sooner or later if she goes not to go away from him. Then when the complainant decided to lodge a complaint before the police, accused number 2 and 3 went to her and brought her back, assuring that they would bring accused number 1 soon from Bangalore and execute an agreement for marriage with the complainant within a week, to the effect that accused number 1 married the complainant immediately after attaining the age of marriage. But although more than 2 months have already gone by, nothing is done. The taking advantage of being in relationship with the complainant, accused number 1 secretly stored some private videos of the complainant beyond her knowledge, and now he is threatening the complainant that if he insists on marriage with him, accused number will upload all the photos, videos via social media and would destroy her life and reputation. All this would go to show that the accused persons got conspired to oust the complainant from the life of the accused number 1, so that he may take another girl of his choice. That the complainant was in deep love with the accused number 1. She has accepted accused number 1 as her husband since 2023, and as such, she is still committed to him and is hopeful of getting him as her husband. That is what I was.
Only last page number 19. Page number 19, first paragraph. All the second line, my lord. On receipt of notice, all the accused persons are threatening her. They were killed by hard guns. It is there, and accused number 4 and 5 physically assaulted her and threw her from Sastigan place.
These are allegations, Your Lordship. I respectfully pay with folded hands, Your Lordship. These are allegations. I am ready to forfeit, Your Lordship. Some protection will be granted to us, Your Lordship. Not be respectful.
Mr. T. Duty. Mr. T. Mr. K. Prasad, the land Mr. P. We have to take this one. Again, the video. Subsequent Mr. Duty also for condition that present expressions are the father, brother, and sister of the accused number 1, and accused number 1 and their have not involved in the alleged offense. Further, he submitted that the entire allegation is brought against the accused number 1, who is claimed to be the husband of the informant, and the accused petitioner number 1, 4 are the only family members / fathers and brothers, father, mother, and brothers and sisters, father, mother, brothers and sisters of the accused informant. However, there will be a the eyes in product of this case in their conflict with the related to the arrest. Context, explain this context. Mr. Parasha, the learning professional PP, has submitted that CD reviewing the actual fact of the case, and further he submitted that some allegations are also brought against the accused petitioner complaint that we expect, considering the submission made by the running council proposals, other than the FIR, I find it is to executive with of injury to represent this petition of the state to receive the case diary and obtain the information. Okay, it will be under interim protection.
CD on 7th of August. Other two items also may be fixed on that day because CD is because
On 7th of August.
19 and 20
The
also.
item number was
19 and 20.
19 and 20.
In that case, is also CD required. So
19 and 20 not 19 and 20 and also
7
3 weeks for issue too. I got 3 weeks. I said it will be 7, 8. 7.
Deeply obliged.
May it please your Lord. My Lord, 482 petition, my Lord. I have come seeking postponement of, my Lord, the order of issuance of summons, my Lord, vis-a-vis the order of framing of charge and the proceeding of PRC, my Lord. My Lordship will find my Lord, before that, my Lord, the petitioner, my Lord, he is an employee of All India CPWD office, my Lord, Kamuni Madam.
You have filed this petition when? In the month of July and June only?
Yes, my Lordship.
Okay.
My Lord.
Okay. So now yes, you have come from 14 years.
My Lordship. Page 31, my Lord. This is order dated 29/3/2023, my Lord. This is an order of taking cognizance. Page 31, my Lord.
Oh. Yes.
So my Lordship will see, my Lord. In this particular case, my Lord, altogether the cognizance was not taken. And directly, my Lord, the summons has been issued, my Lord. Case record is received from learned CGM Kamrup Metro for disposal. Perusal of the case record. Peruse the case record. On perusal of the case record, it appears a charge sheet was submitted against the accused person, namely so-and-so, alleging commission of offence under so-and-so. Issue summons to the accused person. Prepare copies of relevant papers and documents to be furnished to the accused person. Cognizance, without taking cognizance, my Lord, the summons were issued. Then, my Lord, this particular case has been registered under section 354D, my Lord, the stalking, my Lord. So, without taking my Lordship into the FIR directly, my Lord, because 207, the copies have already been furnished to the accused person, and that I have annexed at page 32. Even, my Lord, the ingredients of 354D does not make out, my Lord. 354D, page 32, my Lord, is the statement of the informant. May I read, my Lord? I am an employee of 104 Bamuni Madam office. From home, sometimes I come to office by bus and sometimes by trekker. From last few days, I noticed that one aged person has been following me. Whichever car or trekker I used to board, he also used to board that, and he used to talk over phone in a way targeting me so that I can hear that too. One day I clicked one photograph, she clicked, my Lord, of him without his knowledge so that I can inquire about him, and after coming to office I informed my colleagues about the incident by showing his photograph to them. There I tried to inquire about the address of that person. So this is the, my Lord, sum and substance. So now, my Lord, on this statement, my Lord, whether, my Lord, I stalked someone or, my Lord, the informant stalked me, that, my Lord, is apparent because the photograph, my Lord, has been taken by the informant without his permission. And 354D, my Lord, the language is very clear, my Lord. 354D stalking. Any man who, number one, follows a woman and contacts, my Lord, not all contacts, my Lord. Follows a woman and contacts or attempt to contact such women to foster personal interaction repeatedly despite a clear indication of disinterest by such women. So 354D1, my Lord, it is very clear, my Lord, that anyone, my Lord, any man who follows a woman, my Lord, and contact, has to establish a contact or tries to establish a contact. But in this particular case, my Lord, from the 161 statement as well as the FIR itself, it is very much clear, my Lord, that no contact was established, my lord. Only he was holding the phone and was talking over the phone, my lord. And his, my lord, such conduct disturbed somebody, my lord, resulted in filing of this FIR. Now, my lord, another aspect, my lord, this particular case was registered because, my lord, I filed one petition for seeking discharge, my lord. Discharge number one on the ground that factual position of the case does not, my lord, make out a case under either section 354D or 506, number one, because personal contact is apparently, or attempt to contact is apparently missing. Number two, my lord, I sought discharge on the ground of limitation, my lord, as stipulated under section 468 of the CRPC, my lord. 3 years, my lord. This case, my lord, page 42, if my lordship may kindly come to page 42, that is my petition, my lord, that I have filed, my lord. 42. Third para, my lord. That the accused petitioner expressed that in the present case the FIR was lodged on 13/9/2019 and the accused petitioner was identified during the alleged cause of action. Thereafter, on 13/9/2019, the charge sheet was laid before the Honorable Court and cognizance of the present case was taken on 29/3/2023, my lord, and as such not by the period of limitation as stipulated under section 468 subclause 2C of the CRPC. So, my lord, finally my submission before your lordship is, my lordship may kindly come to page 46, that is the framing of charge, my lord. Third para, my lord, may I read, my lord? Page 46, my lord, Annex 8. To decide the issue above mentioned, I have perused the case record along with the relevant documents submitted under section 173C CRPC and the case diary. From the order sheet of the case record, it appears that the learned CGM Kamrup made over the instant case record to this court for disposal by order dated 23/2023. Page 47, my lord. And this court thereafter issued process for the appearance of the accused by order dated 29/3/2023, my lord. The accused subsequently appeared and was allowed to go on bail. From the materials on record, it appears that the offence took place on 13/9/2019 and the police submitted the charge sheet on 30/9/2019. Thus, apparently, the case is barred by section 468/469 CRPC, for which cognizance ought to have been taken within 3 years from the date of the offence. The prosecution is not in a position to explain the delay ensued in the matter, my lord. So, in the order, my lord, it has been clearly reflected that it is within the bar of section 438, my lord. However, my lord, under section 437, second proviso, my lord, the cognizance was taken. But from the order, my lord, it is clearly reflects that, my lord, what was the materials available on record to exhaust, my lord, 473 for taking cognizance. That is my case, my lord. So at this stage, I pray for issuance of notice and, my lord, till then, my lord, the proceeding of PRC case may kindly be stayed, my lord.
He is already in bail. Otherwise, regarding that, my lord, he is already in notice be issued and
Second August.
It is submitted by Mr. Das that being present with the petitioner, innocent only not connected in the office. Most of from the contents of the FIR, it is said that the case does not affect the under section. There is no material to affect the case under section 54 of habit, as there is no allegation of any personal attempt of personal conflict with by the petition. More so, from the order passed by the learned court will it is seen that the process was issued against the present petitioner without even taking the cognizance of this case. And you have filed the prayer for discharge already.
Discharge, my lord.
And the prayer for discharge is also not done. So, it found that there is nothing in the case the court to establish a case under section 4 IPC, as well as the case is also barred by NDPS. Accordingly, he submitted that the disposal of the petition. He prayed for stay of nothing. He prayed for stay of the which was a what is the
PRC case number, my lord?
362.
362 oblique 2023.
State till next date of listing. If you take this, it will be state till next date of listing. It will be listed up to 3 weeks.
3 weeks. Deeply obliged.
Scan copy in English.
Scan copy.
Highly obliged.
May it please your lordship. Well, here, my lord, we have approached this honorable court for quashing of the complaint case, my lord, 139/24. The complaint case, my lord, basically revolves around one of the complainants, my lord, the electricity connection was disconnected. All the petitioners are electricity officials, lordship, APDCL officials. The connection was disconnected because prolonged, my lord, for a very long period, from September to February, he has not paid his bill. I've annexed his bills on the lordship. And my lord, for disconnection, he has lodged his complaint, your lordship. The complaint starts from page 14 itself. The petitioners are APDCL officials, your lordship. And the main grievance in the complaint is that his connection was disconnected, and we have demanded him some money. That is a false allegation, but connection was disconnected. But we have done it in our official capacity. Lordship knows Section 56 of the Electricity Act empowers the lordship for disconnection, lordship. And since September, your lordship, his outstanding bill was there. I have annexed all the bills, your lordship, starting from page 18. The outstanding was there. These are all electricity officials, your lordship. The petitioner number 1 is a subdivisional engineer. Petitioner number 2 is the assistant manager. Petitioner number 3 is the office cum field assistant. Petitioner number 4 is a Sahaya. When they are disconnected on 0 to 24. After he has not, a lot of knows nowadays, if in Guwahati, if we don't pay the bill for 1 day also, our connection gets disconnected. It is online nowadays. And he has not paid his bills from September. And last bill was page 24, lordship, his outstanding bill was 32,000 something. It got accumulated, then it was disconnected. And after disconnection, he has lodged his complaint.
Yes. Hard to also had Mr. K.K. Brand.
Complaint के सिर्फ केस पे घटना है लिखा होता है
Before it is issue notice to the respond number 2 registered to the Negotiable process, also called. It's a charge-sheeted one.
Lordship?
Case is already charge-sheeted.
No, madam, it's a complaint.
Complaint case.
Sorry, complaint.
Complaint.
Cognizance has already.
Cognizance has been taken. No, summons has been issued. Without that too, without that following that. I don't know whether prosecution sanction has to be taken or not because APDCL nowadays is a government undertaking, but sanction was not taken. That also ground I have taken.
That the only investigation and they went to disconnect the electricity connection of the government as there was outstanding bill since last September 2013, and the outstanding amount was more than 30,000. But after the disconnection of the connection, complainant has now been announced a complaint against the present the petitioners about the top of the also he submitted that as the PDCL is now the overtaking organization, the process was issued even without taking any sanction from the authority concerned. The proceeding of case number so and so
कल लोग 11 में के बाद आते
and maybe and after aspect of the proceeding of the complaint number 159 of 2024 under section 123 420 294 50 Act pending before the court of Learned SPM Hilasipara State within it will be stayed after till next day. 3 weeks is the review.
Oblige your lord. Oblige your lord.
Yes.
May it please your lord. My lord, this is a quashing petition, my lord. I have come against an order, my lord, dated 19 to 2024 passed by the learned JMFC. Before, my lord, I press with regard to this particular order is concerned, my lord, just brief factual aspect of this particular case, my lord. The complaint petition under NIA, my lord, Negotiable Instrument Act was filed by the complainant. Along with the, my lord, complaint petition, one, my lord, evidence on affidavit by writing initial deposition was submitted. That is the normal process. Then, my lord, on 58, because some original documents was left out to be exhibited, the complainant filed one petition. That petition, my lordship, will find at page 58, seeking, my lord, permission to submit those documents, my lord. Page 58 is the petition, my lord. Second para may I read, my lord. That it is respectfully submitted that the complainant is present today before this honorable court and further prays to allow the complainant to produce the original and mark the same as exhibits. Further, no prejudice would be caused to the accused if the same is allowed. That on 31/10/2022 and 10/4/2023, two applications were filed for allowing to exhibit the originals. However, due to inadvertent error, no such prayer could be made. Now, prayer, my lord, allow the complainant to produce the originals and mark the same as exhibits. I never, my lord, objected to such petition, my lord. Then on again, my lord, subsequent date, my lord, when this particular petition was fixed for hearing, the complainant filed another petition, my lord, seeking to withdraw this particular petition and, my lord, with a permission to allow, my lord, the complainant to submit altogether new sets of evidence, my lord. That petition, my lord, you will find at page 60. second para, my lord, may I read? That it is respectfully submitted that the complainant has filed the complaint along with initial deposition. Thereafter, the petition number so-and-so was filed inadvertently by the complainant, and as such, the instant petition is filed to not press, withdraw the said petition. Further, no prejudice would be caused to the accused if the petition number 3673/23 is allowed to be withdrawn. Moreover, no objection was filed by the accused in the petition, my lord, accepted, my lord. Now that the complainant is filing evidence on affidavit in the case, and the same may be taken on record. So this was the petition, my lord. And my lordship may kindly come to page number 51. That was his initial deposition, my lord. Though it is written as initial deposition, but at page 54, para 10, my lordship would find the statement made in paragraph number so and so of this affidavit are true to my knowledge, and the statement made in paragraph so of this affidavit made being matters of record. Page 55, and I signed this affidavit on the 2nd day of March 2021 in Guwahati. So, my lord, then I objected with regard to his first prayer is concerned, my lord, that he wanted to withdraw this earlier petition. I gave no objection. But with regard to, my lord, submission of new sets of evidence, my lord, I gave objection, my lord, which was not allowed by the honorable court below, my lord. Because, my lord, that petition specifically, my lord, no, because three questions has to be ascertained. What will be the fate of this sets of evidence, my lord, when a new set of evidence was allowed to be filed to the complainant, my lord, in presence of this evidence? Because he has never approached the honorable court under section 311 seeking to adduce further evidence. Secondly, my lord, he will get a chance to fill up the lacuna, if any, by filing new sets of evidence, my lord. That was never considered by the court below, my lord. Whether that particular aspect, what will be the limited, my lord, evidence that he will be allowed to lead by way of filing an additional evidence on affidavit, my lord. But this particular prayer, my lord, he was not willing to file additional evidence on affidavit. He wanted to file new sets of evidence on affidavit, my lord, which was allowed by the court below. That impugn order, my lord, you will find at page 65. Fifth para, my lord, page 65. Fifth para, may I read, my lord? On perusal of the case record, it appears that in the instant case, the complainant filed initial deposition on oath in the form of affidavit separately, along with complaint petition, which was filed under section 138 of the NI Act 1881. But learned counsel for the complainant submitted that now the complainant wants to file evidence on affidavit, as the documents based on which the case has been filed is not exhibited earlier. So exhibiting the documents I never objected to. But, my lord, this particular aspect, that filing evidence on affidavit again, in presence of earlier evidence on affidavit, what will be the fate of that earlier evidence on affidavit which was already there on record, filed by the complainant? Nothing has been discussed in the impugn order, my lord. That is why I have come, my lord. So let, my lord, notice go and the complainant come, my lord. So my sum and substance, my lord, my argument is, my lord, that what will be the fate of the other earlier sets of, my lord, evidence. Then, my lord, whether it would entitle the complainant to fill up the lacuna because not a specific direction is there.
Have you cross-examined the...
Not cross-examined, my lord. Not cross-examined. It was fixed for cross-examined.
You will get the chance.
I'll get a chance, my lord.
The other evidences may not be considered by the court. I don't know what they may be. So at this stage, I'll notice.
My prayer is, my lord, that, my lord, this new sets of evidence, the moment it is allowed to the complainant, my lord, whether it will amount to re-examination of the complainant. These are the issues, my lord, never touched by the honorable court below. And this way, my lord, entire in the future, my lord, all the cases, one after another evidence and affidavit will come, my lord. My case is not with regard to the factual aspect of the case, my lord. My cross-examination will be limited to the factual aspect of the case. But my case is, my lord, with regard to the procedure that has been adopted by the court below. Whether that procedure is correct, my lord. Because in the order, there is no mention about, my lord, the filing of new evidence. Because normally, whenever we file section 311 petitions, my lord, we have to give specifically.
In that case, if suppose the other one is also on oath, these are all on oath, suppose most respectfully, then in that case, subsequent new set of evidence that may be considered as maybe as an additional.
I never objected of filing, exhibiting the exhibit.
Because
that
we
is
have to exhibit those documents because it was an interim.
yes. That's why I never objected, my lord. And they have admitted in their petition also, subsequent petition, that I never objected them to filing, exhibiting their documents. My grievance is that, my lord, how, my lord, in presence of one set of evidence, my lord, again the complainant, without approaching the honorable court under proper sections of law, that is 311, allowed altogether to file new sets of evidence, my lord.
Mr. MK Das, then I for it reducing to 397, so for setting a second washing of the open water dated 19/2024, passed by the learned PM at the Camp M, Guwahati in Harassment, case number 617C. What is the stage of the case?
Cross-examination. I pray, my lord, till
stay is not possible.
Because, my lord, once cross-examination is done, my petition will, my lord, get infructuous, my lord.
Okay, till next date of listing.
Next date of listing. Deeply obliged. After, my lord?
3 weeks.
3 weeks. Highly obliged.
Kindly can be passed over for some competition. Kindly.
May I please, Your Lordship? Your Lordship, this petition is filed on 26/6 in the month of June. So Your Lordship may be kind enough to consider under section 482. Your Lordship, this is a dispute, completely family dispute between brother and sister, Your Lordship. So the sister is not allowing her own brother to enter into his father's house. He works in Telangana, Hyderabad, Your Lordship. So what happens, a dispute, and even she has filed a probate case in the district court, being number 18/20, Your Lordship. So what happened, he came in the month of 18th March 2021 to visit his sister to discuss the matter amicably. But she was not ready to discuss anything, and she completely misbehaved them, and she called upon police. So police came with a lady police also, and she saw that the police saw that it is completely a family affair, so they were reluctant to interfere, and they went away. After that, his sister filed an affair against him, Your Lordship. So against which a PRC case has been lost against him, and his wife, this petitioner wife, also lost a case against her sister-in-law, but that is withdrawn under the notification of government, Your Lordship, that 3 years imprisonment cases are withdrawn. But unfortunately, the case lost against him by his sister, that is going on, Your Lordship. So, Your Lordship, kindly notice be issued, and the proceedings going on in the lower court may be stayed for the time being, Your Lordship, because it's very much.
Then why don't you approach the court that if it is supposed
one case should
already withdrawn, and if you want to say that this is also.
But only for one section, Your Lordship, that is section 350.
If your section is also comes under.
No, Lordship, only one section, that is section 354, that is not coming within, that's why only the case is going on.
354 is there.
Yes, Your Lordship. Your Lordship, kindly notice be issued and proceedings may be stayed, Your Lordship.
What is the stage of the case at present?
Your Lordship, it is for appearance of the accused.
Brother, 354 is there, but going by the FIR page 27.
URMS S. Sharma?
Yes, sir.
Hard MS S. Sharma, and also for the addition to the state response to the reference number to the expected judicial process. Also call for the scan copy of the election. No problem of this is required to this website. Next, is submitted by S. Sharma that this is a case between the brothers and sisters, and dispute arose only for property when the present comments not allow the present petitioner to enter into his party's property. It is only for the property for him, but okay, it will be stayed till the extent of this will be listed after 3 weeks.
Highly obliged.
Takes days for complete notice to the response.
Your Lordship, I have one more submission, Your Lordship. Unfortunately, there have been two typographical errors, Your Lordship, in page number 15 and 24. The name Sanjeev Das, it would have been Sanjeev Das, but it has been by mistake written as Sarma. And
15 and?
Page number 15 and 24, Your Lordship.
What Sharma?
It would have been Sanjeev Das, not Sarma.
Oh, skill number 3. There is Sanjeev Das बोला है ना?
Properly इसलिए And page number 24, Your Lordship. Your Lordship, if I am allowed, I may be correct in the court copy.
No.
Nowadays
you cannot. You have to file a fresh.
Lordship, and page number 20.
In that case, your FIR petition will not go. We are not going to pass any order in that case. We are listing it on day after tomorrow, make a correction. Corrected copy may be by through an additional affidavit.
Additional affidavit.
File the correction.
Day after tomorrow. Obliged, Your Lordship.
Day after tomorrow.
Obliged.
Day after tomorrow and Saturday, 17th.
Obliged.
May it please Your Lordship, related to application for quashing of the criminal proceeding that has been drawn up against this petitioner, accused petitioner, and is currently pending before the Court of the Learned Subdivisional Judicial Magistrate Margarita in connection with case, CR case number 22 of 2019. Now, Lordship, before I start, would like Lordship to kindly peruse to page number 27 of Annexure B. This is the complaint petition, and from where it is entire complaint has been drawn up. 27, third paragraph. That on the Independence Day, that is on 15/8 of 2019, at about 12:30 p.m., while the complainant's son, named Sri Aryan Datta, was going towards Margarita College riding a motorcycle, and when he was about to reach Margarita College through a very narrow road, suddenly one Bolero pickup vehicle appeared from the other side, being driven by one Sri Deepak Das, and to avoid any collision, both of them stopped their respective vehicles. After stopping, the driver of the Bolero asked the complainant's son to ride the bike carefully, to which he reacted nicely. But suddenly one SI Sri Digonto Kolita, SI of Margarita PS. He is the one, he is the petitioner. Came there from the backside, riding on his bullet motorcycle, and asked the complainant's son, how dare he overtake his bullet on way few minutes ago, and using slang language, he asked him to get down from the bike and started assaulting him with fist and blow on the spot. And then he took him to Margarita police station along with the driver of the said Bolero. So this is the main brief of the incident that has happened. Now what has transpired after that is that when this incident happened, the SI, Digonto Kolita, he had not pursued this vehicle from backside, first of all, because he had first gotten information, and as per the information that there was an accident that has happened, and once he got that information from his superior authority, he went to that place of incident to inquire about it. He did his investigation, and once he came to know that there was an accident that has happened, he had recorded everything in his GD. GD entries are there, which I will peruse. In the GD entries, he has appropriately he has mentioned all the procedure he has undertaken under the under his obligations, and then he has proceeded as per law. Now this complainant and his son, this complainant, this is Manoj Dotto. What he has done is that his son actually, while he was driving his motorcycle on that day, he did not have a license. There was no proper insurance, papers were also not there. So it was absolutely a case of accident, and at the same time there were materials which were there which could have been led to initiation of criminal proceeding against him as well as a motor accident case. And as per that, this Digonto Kolita, this SI, while he has taken him to the police station, he has did every formalities which he has to do under the police manual. He has undertaken all the procedures, and then what has happened? This complainant, the son of the complainant who was there engaged with the accident, he had drawn up this complaint case against this SI Digonto Kolita, and now he has preferred this application so that the case which is currently being pending should be stayed at this moment, at this stage, and the record should be called so that a proper adjudication of the matter should be done. Because of the fact that this police officer, he is currently serving as a sub-inspector of this Lota Cell police station. He is diligently performing all his, discharging his duties in his official capacity. Now what has happened is that this person, this complainant, in order to avoid that any accident case should not be reported or it should not be initiated, he had filed this complaint petition so that he can negate the accident case. But unfortunately, he was not able to do so. Kindly peruse to page number 59, that is Annexure J. That is the order that has been passed by the judicial magistrate who had taken up the non-FIR case, which was registered against this complainant's son, page number 59. So there it is very well, it has been exposed that what has happened. There the complainant's son himself has admitted and he has pleaded guilty. And as such, he was later on, fine was imposed on him, looking at his earlier antecedents. So this shows that this entire case was there mainly because this complainant's son's father, he wanted to make a case to negate his son's failure to comply with the provisions of the Motor Vehicle Act, and then what he has done is that in order to negate that case, he had filed this case against this diligent police officer. This is the case. So currently now it has been pending before the learned subdivisional judicial magistrate Margarita, and it is now on the stage of charge has not yet been framed. So it is still charge has to be framed. So it is at this stage. The cognizance order is on page number 23, Annexure A. That is the cognizance order. Order dated 7/11/2019.
Lordship, here on 13 to 24, the petitioner was already granted bail, Lordship, and the case is fixed for evidence before charge, Lordship. And the private parties are there, let the notice go, Lordship.
Yes,
and in the meantime, scan copy may be called for, Lordship.
of one dinner council petition and also had Bishop Margarita PS on behalf of at the section students for connection. Issue notice to the private the respondent number 2 with digital agent and the process. So formal notice required to understand also called for the scan for details. Mr. Meeting and council for petition for the present this petitioner is a person and he has not committed any of the that is in there. It is a fact that one accident was taking place where the son of the informant that the respondent number he is the respondent number 2.
The informant, Aryan Datta's father, the informant is he's a complaint.
So he is now Aryan Datta is also one of the parties.
Yes, we have made two parties, both the son as well as the father.
Son of the informant, that is the informant number 2, 3 was arrested by the present petitioner after obtaining informed police and informed but only to negate the accident. The present petition, the present FIR has been now taken. The present complaint has been now taken to the present petition with some consent of litigation. Accordingly, he submitted to disposal of accordingly based on state disposal of your prayer is allowed, stay will be there.
Yes, ma'am.
And it will be listed after 4 weeks.
Yes, ma'am.
Take steps on the respondent. Take steps on the respondent.
Obliged, ma'am.
May I please, my lord? This is a petition that has been filed invoking inherent jurisdiction and revisional jurisdiction of this honorable court. Now, my lord, at the outset, I would like to humbly submit before this honorable court that we are not challenging this case on its entire merit, but we are basically challenging, by way of this particular petition, a particular order passed by the learned trial court. Now, my lord, may kindly come to the order which is a subject matter of challenge in this particular petition. Now, my lord, that particular order I have annexed at page 86. My lord, basically, a DRI has filed a case before the learned trial court, and upon receipt of that particular case, this order has been passed by the learned trial court. Now, I may be allowed to read, my lord. DRI is represented by the special counsel. Accused Gopal Chandra Rai is produced from judicial custody through VC.
You are representing the DRI.
DRI, my lord. My lord, may I continue? The investigating officer has submitted the charge sheet for an offence under section 8C, 20B, Roman 2C, 22C, 29 of the NDPS Act against the accused person, namely Gopal Chandra Rai, Liton Malakar, Kajwal Malakar, Chili Ghosh and Subroto Ghosh. My lord, this is a petition that has been filed on behalf of Chili Ghosh and Subroto Ghosh. That is accused number 4 and 5, my lord. Now, once the record of the case has been perused before the learned trial court, accordingly the learned trial court has to cognizance. Now, my lord, may kindly come to page 87. As the accused person, namely Liton Malakar, Kajwal Malakar, Jhilik Ghosh and Subroto Devnath are shown absconder, hence issue warrant of arrest against the absconded accused person. Now, my lord, I would like to submit that this is not a case where the investigating officer has submitted the charge sheet, because there are two categories of officers under NDPS Act who can do the investigation. First is the police officer themselves, and second, my lord, those officers who are invested with the power of the officer of charge of a police station. And these officers are empowered under section 53 of the NDPS Act. Now, my lord,
The moment they have done their investigation, there are two courses that are available to him. The first course is that, my lord, they can file a report under section 173, subsection 2. But if a charge sheet under section 173, subsection 2 needs to be filed, my lord, first of all, the report has to be submitted to the concerned Chief Judicial Magistrate Court. And the same report has to be forwarded to the Session Court or even to the Special Court, my lord, in terms of the NDPS Act. But, my lord, in this case, my lord may just come to page number 19. Now, this is the complaint, my lord, that has been filed by the DRI officer who is empowered under section 53 of the NDPS Act. My lord, I'm just reading the opening part of this particular complaint. A final complaint under section 36A of NDPS Act 1985 for contravention of so and so. My lord, this is a complaint that has been filed. There is no charge sheet filed in this instant case. That is first aspect of this matter. And secondly, my lord, whenever the complaint is filed, there is no provision under NDPS Act or even the CRPC to show some accused as an absconder, my lord. At first instance, my lord, it is a duty of the court to issue summon. If somebody, in spite of the receipt of the summon, he failed to appear or did not appear before that particular court, of course, court can exercise its power and subsequently issue arrest of warrant. But directly, my lord, against the accused person, it is not permissible even for the court to issue warrant of arrest. So at this stage, my humble prayer before this honorable court is to let the notice be issued to the DRI. I think the copy has already been served upon them, and further proceeding of this particular case may be stayed, my lord, in this case.
Your Lordship, my senior, he is out of station for his mother's illness, so kindly grant some time for him.
Sorry?
My senior, he is out of station for his mother's illness, so kindly grant some time for him.
Well, let the notice be issued.
Okay, we'll issue notice then. Notice for it. No formal notice is required to be issued, so it's not. Ramek, who is Union of India represented by Sri Ramek Pal Roy, means who is the intelligence officer?
The prime accused
you
is...
have made party by personally you have made party to some Mr. R. Roy.
No, my lord, R. Roy is the accused number 1. Gopal Sundar Rai is the accused number 1.
No.
I am not representing him, my lord.
No, you are not representing him. Srimati
Yes, my lord.
And so versus Union of India, represented by one Sri Ramek Bhai Roy.
Ramek Ubali Roy. My lord, he is the investigating officer and he has filed the...
Personally, you made party.
Yes, my lord.
Why?
No, personally, he is... My lord, Union of India is represented by him.
They will represent.
My lord...
So he is the intelligence officer, director of Juvenile DRI.
Yes, my lord.
So by name or by personally, you have made party.
No, my lord, I have made the party Union of India.
Is Union of India represented by someone, some name is there, Ramek Bhai
Yes,
Roy?
he is the...
Why? So we have to issue notice again to see Ramek Bhai.
No, my lord, it is not necessary since he is one of the DRI officer, my lord.
DRI officer, DRI will represent them.
DRI will represent. My lord, DRI will represent.
We DRI, on behalf of specifically DRI, represent the Korean disability board. Notice has already been and call for the scan box. This case cannot be stayed.
No, my lord, there is several judgment of the Honorable Apex Court, my lord.
Let's see the order. We'll go by the order. Not stay.
No, my lord, I already have a copy of the judgment, my lord, where Supreme Court has stated. The first instance,
now the next date, in his presence of his her senior, and then we'll see. It will be listed up to
my lord, then in
the matter, you can come, that is different aspect regarding the issuance of the, NBW. That is different. But you have come to for the entire washing and all, and then again you have also raised the issue in regards to the filing of the subsequent
Charge sheet, my lord.
is absent method, it has to be.
No, my lord, then
Okay,
they may be considered on next date, my lord.
Pardon?
Interim pay may be considered on next date, my lord. That may be recorded.
Okay, interim period may be considered on the next day. Date can be fixed on August 4th, 5th August. 8 August. 8. By this time, we are issuing notice and we are also calling for details.
Deeply okay.
Submission waiting.
May I please, Your Lordship?
Yes.
In this case, I have challenged the cognizance order, Your Lordship.
Order of cognizance.
Cognizance. Fact of the case is that, Your Lordship, I am submitting. Petitioner before Your Lordship is a subject teacher of a school.
Yes.
And informant son is a student of class 8 of that school. And when the petitioner was taking class 11 of mathematics, then informant son entered into the classroom and disturbed them. He was physically assaulted by the teacher, petitioner. Your Lordship. Then the informant lost affair. Page 14 is the affair. Page 14.
He was assaulted.
Informant son was assaulted. Is a student assaulted by the petitioner, is a teacher of that school. Because he is disturbed in the class. Of another class is entered. Page 14 is the affair. You got it. Page 14. Is the type copy. 17 is the original. Page 14. You got it. Application for child cruelty. I, Mohammed so-and-so, resident of Thermal Gate, wants to state that today at morning, my son has bitten by teacher and so-and-so, very badly. The said teacher has bitten my son cruelty that he had got several body injury. The case is registered, Your Lordship, under section 343, 323. It is section 75 of the Juvenile Justice Clarification. Now, Your Lordship, turn to case 19. In this case, Your Lordship, the next day, because the case was lost and they have settled the matter. Case 19 is the final report was submitted in this case. Case 19, Your Lordship. Case 19. Final report, Your Lordship. Second para, Your Lordship. During investigation, I have visited the place of occurrence and drew a sketch map of the place of occurrence and kept on record. The statements of the informant and other witnesses are recorded. It is hereby mentioned that during the investigation, the informant submitted a mutual agreement executed before the court notary and further stated that both the parties has amicably settled the matter and intimated that she is not interested to proceed the case in future. After discussion with the officer in charge of the police station, I have submitted the final report before the Honorable Court that though the case was registered under section 342, 323 IPC, but it was filed due to misunderstanding in the parties, the final form of the case has been intimated to the informant. A copy of the suspension.
Okay, then FR was submitted.
FR submitted.
And the cognizance was most probably taken.
Yes. Cognizance.
Page 25.
Page 24. The order you are listening. Notice was page 24. Kindly said your notice was issued to informant. Page 24. Order dated. The informant appeared and filed petitioner so-and-so submitted that she has no objection to acceptance the affair final report in this case. But after page of case, we found that it is necessary to go to the case report and the case diary properly before passing in this order. And after that, you have page 25, order in 124. In this case, on the last date, the informant appeared and raised no objection to the final report.
That is there. That's it. Though she said that she has no objection in accepting the
final report.
The magistrate read the case diary and found sufficient metric. So against that order you have.
No, Lordship. After Lordship, revision was preferred. One revision was
yes, revision
page 30.
Page
30.
30. Revision was preferred.
And should we find the order? The
page 31.
Part is Lordship. 34 Lordship if kindly comes.
Yes.
35 Lordship. Operative portion Lordship. 35. Paragraph number 10. No.
Paragraph 10. I am reading. On receipt of the police report of so-and-so, the magistrate can exercise three options. Firstly, he may state that there is no sufficient ground for proceeding further and drop action. Secondly, he may take cognizance of the offence under section 191B of the CRPC on the basis of police report and issue process. Thirdly, he may take cognizance of the above offence section 191A CRPC on the basis of original complaint and proceed to examine upon the oath complaint and his witnesses under section so. One case is cited, Your Lordship, Junaid by State of so. While accessing judicial execution, magistrate has to apply his mind to content the protest petition or the complaint as the case may be. This citation, it is rely upon the judgment. It is not. It is different, Your Lordship. In this case, I am that.
No, judgment. Let's forget about the judgment. It is supposed if it's not applicable also, but there are options.
Lot of options there.
So when he, went through the case diary, the magistrate found sufficient material.
Yes.
That's why cognizance was taken. The revision was just missed.
Yes.
Now against the revision, this is fine.
Later, that is.
Record this one.
Issue notice may be going. That judgment is, it is there is a rely upon the revisional code. I am saying that judgment.
Okay,
It is that
different, but there is specific provision.
a provision is there. 190 magistrate has power.
Magistrate has the power. Magistrate has the power.
But in this case,
If you find. But yes, obviously, if you go by the record there, if there is no material at all or something, maybe a case, I don't know.
But in this case, while the information of interstate and there is not a heinous crime, there is a relation with husband teacher. And protest petition is
yes, for sometimes teacher has to be strict. That is that. But the torture or the physical torture on the that student or the child, it's most probably this severity of the torture was so bad that cognizance was taken. I don't know what about the what is
the words used by the magistrate is severe torture.
Severe torture. Severe torture.
Notice
so that's why the magistrate is in the opinion that
Let the records come.
yes.
Till that they quotation may be wasted because it's a teacher.
Record for. From where it has to come, record?
Tinsukia.
Tinsukia. So after 3 days? Just after. Not updated.
Lordship, may I submit, Lordship? Lordship, this is an application under 483 of BNSS, Lordship.
In the morning hours, he was not there. Mr. Thakur
Yes,
was not
he
there.
was not there in the morning.
I was
submitted.
Yes, I was there. And actually,
He
item
submitted
number
that
13
CD
case diary
available.
was fixed today. Item number 13. And item number 12 has been listed for the first time in the motion column today. And as actually both these cases has arisen out of the same PS case, both this matter came in the motion. So,
You are
CD might be there.
You are for the item number 13.
13, actually.
You are for 12.
12.
Yes,
Lordship, the petitioner was sworn arrested in connection with the present case, Lordship, on 10/6/2024. The allegations are under section 380 and 457 of IPC, Lordship. And Lordship, the petitioner as on date 39 days behind the bar at this present case, Lordship. Otherwise 60 days offence, Lordship. 39 days behind the bar. So in this case, Lordship, the petitioner is sworn arrested purely on suspicious ground because nothing has been recovered from the possession of the petitioner, present petitioner. Moreover, there is no question of being recovered as the petitioner is behind the bar since 5/5/2024 in connection with Hatigao PS case number 87 of 24. So he is already behind the bar since 5 May, Lordship. And in this present case, Lordship, he was sworn arrested on 10/6, Lordship.
When the incident has happened?
The offence, alleged offence, the FIR is on page 19, Lordship. The vernacular is on page 23, Lordship. It is FIR dated 27/4/2024. I am not the FIR name accused, Lordship. May I read the FIR, Lordship? this is to inform you that our house has been robbed while we were away for a family visit to Tinsukia. When we returned today morning on 27/4/24, to our surprise, we found that one window panel and grill was broken to enter the house. All the almirahs were broke open, and the precious value items were stolen, which include cash and jewelry, Lordship. So basic allegation against the present petitioner is, Lordship, in three of the cases, Lordship, the present petitioner received the stolen article, Lordship. He has a jewelry shop, and the allegation is made against him that he received the stolen jewelry, Lordship, and melted it and changed the shape. Both same objection are all the three cases. If your Lordship has perused the forwarding which I annex with the other cases, Lordship, all are section 380, 457 are implicated against the present petitioner, Lordship. Since considering the length of detention, Lordship, as the present petitioner is behind the bar since 5/5/2024, Lordship, already 70 days behind the bar, as on that 71 days, Lordship. So there is the custodial interrogation of the present petitioner may not be required. Moreover, Lordship, in the first case, Lordship, the Hatigao PS case number 87/24, the petitioner was undergone 8 days of police custody also, Lordship. I have annexed the forwarding and re-forwarding of the petitioner also. So he was already undergone 8 days of police custody. We have already allowed to go on bail on 87, the date case, Lordship. So I have already undergone 8 days of police custody, Lordship, thoroughly interrogated by the investigating agency and sent to judicial custody. Thereafter, Lordship, about 20 days, after 20 days, again the petitioner was arrested in connection with 86 of Hatigao. Earlier it was on 87 of Hatigao. Again he was arrested on 86 of Hatigao by the same PS after 20 days. Lordship, that this arrest is made just to harass the present petitioner. Again, in 86 also the present petitioner enlarged on bail, Lordship, by this honorable court. In 86 PS case also, the present petitioner is allowed to bond. Thereafter, again, about 20 days later, Lordship, he was again shown arrested in connection with this present case, Lordship. So, petitioner is behind the bar since 70 days, and custodial interrogation at this stage may not be required, Lordship. Since already 39 days in this present case also, I am behind the bar. Lordship, any condition may be imposed upon me, Lordship. At least custodial interrogation may not be required at this stage, Lordship, since I am 39 days behind the bar. Otherwise, Lordship, there is no chance of recover also from my position, because I was already behind the bar since 5/5, Lordship. And in the present case, I have arrested on 10/6/24, Lordship.
My Lord.
And in this case, Lordship, the co-accused Siraj Ali was allowed to go on bail by the session court, Lordship, Honorable Court of Additional District and Session Judge Nong 5. I want to submit the order also, Lordship. And another co-accused, Tomser Ali, who was first arrested in connection with this present case, he was also allowed to go on bail, Lordship. These cases, I was arrested in these cases just to, Lordship, yes,
any other submission from you?
Yes. My submission is also to something similar to my learned friend, and I was actually initially arrested in connection with Hatigao PS case number 87 of 2024 on 8/5, and thereafter on 21/5 I was shown arrested in Hatigao PS case number 86, Lordship, and subsequently on 10/6 I have been shown arrested in connection with this case. And in this case, the police has put the section 457 in a mechanical manner, Lordship. The narration in the affair does not disclose that the theft took place during the night hours, Lordship. There is no mention about after sunset or night, nothing. Just an information, kindly peruse page 13 lordship. Page 13 of item 13. This is the affair what has been read by my learned friend, that herein this is to inform you that our house,
name is there.
yes, Lord, and in this information, lordship, there is no mention about the time, lordship. They informed that when they were absent, their house were looted or robbed. So, but the police has put the section 457 to prolong the detention only, lordship. So 457 will not come into play in absence of any material prima facie. In the 161 there may be something, 164 there may be something. I am not in that. And lordship, this petitioner is behind the bar since 10/6 in connection with this case. And as per my calculation, almost 36 days as on today. And in Hatigao PS case number 87, this petitioner has also been granted bail. Another co-accused person has been granted bail in 86 also, Shiraz Ali and Tomsir Ali, and other accused person has been granted bail by the lower court, the Honorable Court of District and Sessions Act. So my humble submission is that the petitioner has been detained since long, lordship, almost around 70 days, and their custody has been taken repeatedly in connection with all these cases. So, considering length of detention,
otherwise,
this may be considered, and nothing has been recovered. That is to add, lordship. That is, nothing has been recovered from my petition, lordship. Nothing.
Where is your ground of arrest?
Yes.
Oh, so is shown arrest? Okay.
Yes, I have been shown arrest in this case. Shown arrested?
Yes.
My lord, modus operandi in all the cases is same. There are three different victimized persons, my lord. In all the, my lord, three affairs, there are, my lord, three. One is, my lord, in the present case, that, my lord, one Chitra Madhav Barua in his house, and modus operandi in absence of all the family members, house owners, my lord, in these accused persons, my lord, by housebreaking at night, my lord, they looted all these articles, my lord. And here in the second case, one Rohit Kumar Thakur, and the houses of all these, my lord, victimized persons are in the nearby area, my lord. And so, my lord, these are, my lord, persons, my lord, who initially, my lord, they are, my lord, organized. This is in this manner, my lord. How, my lord, knowing fully well that no one is there in that house, my lord, they committed all these type of offense. So in all these offenses, definitely, my lord, against unknown persons, because how can my lord, house owner came to know that, my lord, only after in their absence, well, all these, my lord, incidents happened. Only thereafter they came to know about the incident, and immediately thereafter reported to the police. Then definitely, well, against unknown person, and thereafter during investigation, police has recovered some of the items from these from some of the accused persons. Those items were also identified, my lord. And in respect of other some of the accused persons, yes, your lordship, coordinate bench of this honorable court has granted bail, but that cannot be a ground for getting bail in these cases, because on that same day these cases were also listed and case diary was called for. And today, my lord, the motion case PD is not available with me, my lord. So my prayer before lordship, because these are habitual offenders, my lord, continuously, my lord, they are involved in committing all these offences, not only one in single house, my lord, in the nearby area, in three different victimized persons, and for which, my lord, three different affairs laws, my lord.
My submission at this case is that their involvement, I am not denying whether they are involved or not. My submission is that, considering length of detention, they may be allowed to go on bail. They will face the consequences, they will face the trial. Any stringent condition may be imposed. They are local resident of Assam. They are not outside. So in other cases, they have been granted bail. So they will face the consequences. If there is involvement,
after
they will face the
getting
trial.
bail, they will again commit same offence, my lord.
How far the government can...
My lord, he himself, my lord, submitted that, lord, he is not denying their involvement.
No, I am neither denying nor admitting. That is a matter of trial.
He can say, my lord, he can prevent.
I am not vehemently denying, because I have no such material, no any material. So I am fairly submitting that I am neither denying nor admitting. They will face the consequences now. Any condition may be imposed.
More or less submission. One in one case, in case number he is in custody since 5-5. Above prima difference to position 5-5, and in other he is in custody since 8-5. In 10 number from 8-5, in 12 number from 5-5. We are Mr. Student this is an it is submitted that he was innocent and he was shown arrested in this case on 10/6/2024, and hence there is a question of recovery from his position does not arise. Also, he was arrested for the connection with Hatigam PS 2024, and then he inputs of the report wherein he was also under police custody for the corporate period. In connection with this case, the present accused commissioner was shown arrest on 10/6/2024, and thus he is more than 35 days in judicial custody, and hence further custody verification may not be necessary for the interest of the investigation. In this context, Mr. Gordon has submitted that in all three cases, that is in Hatigam PS number 86 of 2024, Hatigam PS number 87 of 2020, and in the instant case, the modus of operation, and they used to loot or rob houses when the family members are absent in the house, and it's safe locally. They are the habitual offenders, and hence, without reasonable anxiety, it's submitted that and accordingly submitted that further custody interrogation may be necessary, and it insisted call for it. In the context, Mr. Peliva submitted that though the FIR dates for timing is mentioned, two cases have been registered under Section 457 of IPC. According to Quality, he submitted that they are ready and he is ready and willing to cooperate with IO in further investigation of this case if he is interested. Next, considering submission made by the learned counsel for the petitioner, learned counsel for both sides, and considering the nature of offense and the nature of offense and also considering the fact that the persons are arrested in similar kind of offenses earlier, I find that the user of the case record may be necessary, case diary may be necessary, and hence let the matter be fixed. It is from which this
19 may be fixed, Lordship. Actually, on 19 already
for co-accused, Lordship.
Already for co-accused has been fixed, Lordship.
19.
On 19, Lordship.
In BA number 2023 of 24.
BA number
2023 of 24.
2023 of 24.
Yes.
On 19th?
19/7, Lordship.
On 19th, it has been fixed.
Okay, we are listing it on 19th.
Lordship.
As per my instruction in this case, my lord, charge sheet not yet submitted. Today is 53 days.
Otherwise, it is 60 days of it?
Yes.
60 days.
Yes.
And is there any probability of submitting within 4 or 5? Do you have any such kind of?
Regarding that, my lord, there is no such instruction. Because, my lord, these persons are fleeing from justice since long. Case was although registered in the year 2019. These present accused persons were arrested only on 23/5/24. So they were running away from police investigation.
that if you are driving a car of someone, some
Officer.
Baniala, Vansit,
Yes,
whatever,
yes.
then why the other objectionable document was found in your possession?
Lordship, that one I have made a statement, Lordship, that he deals with these used cars, Lordship.
Huh?
Used cars means second-hand cars, Lordship.
All the used cars are with him.
No, Lordship. Only this vehicle. This. That one was without number plate. Hospital put stringent condition, Lordship. Hospital put stringent condition, Lordship.
The person is from Meghalaya.
Yes, Lordship. They will give surety, Lordship. If
They
Lordship can
are the
impose
members of my lord
government-
interstate vehicle lifters.
government surety also, Lordship.
Interstate vehicle lift.
Vehicle lifters, my lord.
This is an allegation, Lordship.
So I was asking you whether they are ready to file. If it's not ready, cases of 2011. Yes, whatever, any submissions. Because otherwise, maybe interstate car lifter he may be, but he is behind the bar and did that two cases, no case.
Only on the ground of length of detention.
Part Mr. M. Ahmed, it item number 15. Item number 15. Part Mr. M. Ahmed, also prosecution. And also part Mr. P. Ward. It's on P and SS of goods. It's affected under section 483 of P and SS. Other 3. So, it's subject Mr. Ahmed, the present petitioner, is innocent and he was However, on 23rd of May 2024, the petitioner came to court for purchasing some accessories for his maternal uncle in his maternal uncle's vehicle. And he was arrested by police on suspicion that the vehicle which was driven by him was a stolen vehicle, as the number plate was not there. But the vehicle belonged to his maternal uncle, and she already preferred an application for Jimma of the vehicle, claiming herself to be the owner of the vehicle. He further submitted that the accused petitioner was arrested in connection with this case on 23/5/2024, and hence, considering his length of detention, he may be enlarged on bail. Next paragraph, Mr. Bottom submitted in his connection that the present accused petitioner was arrested on suspicion that he may be a member of interstate car lifter, and some objectionable documents were also recovered from the possession of the president. However, he submitted on inquiry made by him. It was informed by the investigating officer that case is still under investigation and the charges did not get submitted by the I, nor there is any probability of submitting charges within the statutory period. considering so without going by the merit of the case and only considering the decision undergone by the accused. Allow for removal which insecurity consideration to the officer. It is pending before in which
CGM Lordship, CGM Kamrup Metro.
CGM Kamrup Metro.
I am obliged.
Yes.
May I please, Your Lordship? My Lord, this is a 482 application, my Lord. Basically, we are challenging a complaint petition, my Lord. Complaint petition. I beg to draw my Lordship's attention to the complaint petition, my Lord, which is at page 29. If my Lordship permits me, my Lord, I would like to read over the vernacular, my Lord, which is very clear, which will start from, my Lord, is at page 34, but my Lord can skip the 34 part. It is the format, my Lord, regarding the name of the accused. And my Lord, may kindly note, the accused name has been given, the petitioner number 1 is the accused number 1. And the petitioner number 2 is the accused number 4 here, my Lord. Page number 35, my Lord, starts the complaint. May I read, my Lord? বিচাৰপতি গোচৰৰ নিবেদন এই যে গোচৰীয়া এজন অতি নিৰীহ ও শান্তিপ্ৰিয় লোক হয়, আনহাতে পদকীয়াগণ দুষ্ট, দুৰ্দান্ত আৰু অসৎ প্ৰকৃতিৰ লোক হয়। গোচৰীয়াই একে গাঁৱৰে ক্ষুদ্ৰ মাটি বাহা চুবুৰীত স্ত্ৰী পুত্ৰসহ সুখে সন্তোষে বসবাস কৰি আছিল ও আছিল। গোচৰীয়াৰ পত্নী শ্ৰীমতী মিতালী দেৱী পাঠক গোচৰীয়াৰ অতি মৰমৰ পত্নী হয় আৰু তেওঁলোকৰ দুজন ল'ৰা সন্তান আছে। প্ৰথমজন ল'ৰা বৰ্তমান মেংগালুৰুত NITত BTech মেকানিকেল ইঞ্জিনিয়াৰিং পঢ়ি আছে আৰু সৰু ল'ৰা শ্ৰেয়মে বৰ্তমান আনন্দৰাম বৰুৱা একাডেমী পাঠশালাত পঢ়ি আছে। গোচৰীয়াৰ 2 পুত্ৰ অত্যন্ত মেধাৱী হোৱা হেতুকে পদকীয়াগণৰ লগত কিছু সংখ্যক লোক ঈৰ্ষান্বিত। সেয়ে যিকোনো প্ৰকাৰে গোচৰীয়াৰ পৰিয়ালৰ ক্ষতিসাধন কৰাৰ বাবে পদকীয়াগণে সদায় যত্ন কৰি থাকে। একমাহ পদকীয়াগণ গুণজ্যোতি শৰ্মা আৰু গোচৰীয়াৰ পত্নী মিতালী দেৱী পাঠক স্কুলীয়া দিনৰে একে শ্ৰেণীত পঢ়াৰ সোৱাদত 1 নং পদকীয়া গুণজ্যোতি শৰ্মাৰ লগত মাতবোল আছে। এই সোৱাদতে 1 নং পদকীয়াই গোচৰীয়া পত্নীৰ লগত প্ৰেমৰ সম্পৰ্ক গঢ়ি তোলে আৰু গত ইংৰাজী 28/11/2022 তাৰিখে গোচৰীয়াৰ ধৰ্মপত্নী শ্ৰী মিতালী দেৱী পাঠকে ৰাতিপুৱা প্ৰায় 9 মান বজাত মাকিবহাৰ চকত থকা এখন বিউটি পাৰ্লাৰলৈ চুলি ষ্ট্ৰেইট কৰিম বুলি ওলাই যায় আৰু পাৰ্লাৰত প্ৰায় 5-6 ঘণ্টা লাগিব বুলি সৰু ল'ৰাটোক কৈ যায়। কিন্তু আবেলি 5 বজা পৰ্যন্ত ঘৰলৈ ঘূৰি নহাত গোচৰীয়া চিন্তিত হৈ পৰে আৰু চিন্তিত হৈ চাৰিওফালে বিচাৰ খোচাৰ কৰোঁ, কিন্তু মিতালীক ক'তো বিচাৰি নাপালোঁ। পাছত গম পালোঁ যে 1 নং পদকীয়াই গোচৰীয়াৰ স্ত্ৰীক প্ৰেমৰ নাটক কৰি চল চাতুৰিৰে প্ৰলোভিত কৰি ভয় ভাবুকি দেখুৱাই অপহৰণ কৰি লৈ যায়। গোচৰীয়া আচলতে 1 নং পদকীয়া সন্দেহৰ চলৰে চোৱা নাছিল, কিয়নো 1 নং পদকীয়া এজন প্ৰাক্তন BSF জোৱান আৰু তেওঁ বিবাহিত আৰু তেওঁৰ পত্নীৰ ফালৰ পৰা এজনী কন্যা সন্তান আছে আৰু তাই বৰ্তমান ক্লাছ 9ত পঢ়ে। উপায়ন্তৰ হৈ গোচৰীয়াই নিজ পত্নীক উদ্ধাৰৰ কাৰণে টিহু থানাত এখন এজাহাৰ দিয়ে আৰু সেই এজাহাৰৰ ভিত্তিত ৰেজিষ্টাৰ নম্বৰ 0123/2022 এটা কেছ ৰেজিষ্টাৰ কৰে। আৰক্ষীৰ অনুসন্ধান মতে 1 নং পদকীয়াই গুণজ্যোতি শৰ্মাৰ মোবাইল লোকেশ্যন গুজৰাটৰ খাম্বালাত পোৱা যায়। আৰক্ষীৰ পৰামৰ্শ মতে গোচৰীয়াৰ সৰু ল'ৰা আৰু ফুলখালী পুলিচৰ লগত উক্ত খাম্বালালৈ লৈ যায় আৰু তাত গোচৰীয়াৰ পত্নী গুণজ্যোতিৰ লগত পাই গুজৰাট পুলিচৰ সহায়ত গোচৰীয়াৰ পত্নী মিতালী দেৱী পাঠকক উদ্ধাৰ কৰে আৰু টিহু থানাত হাজিৰ কৰায়। মিতালী দেৱী পাঠকে গুণজ্যোতিৰ ভয়ত টিহু থানা আৰু টিহু আদালতত তেওঁ দিয়া জবানবন্দীত স্ব-ইচ্ছাই যোৱা বুলি কয় আৰু আদালতে মিতালীক নিজৰ জামিনত যাবলৈ দিয়ে। ইয়াৰ পিছত মিতালীৰ নিজ মাতৃ শ্ৰীমতী ৰঞ্জু দেৱীয়ে তাইক নিজৰ ঘৰলৈ লৈ আহে আৰু গুণজ্যোতি শৰ্মা জামিনত খালাচ হয়। তাৰ পিছত গুণজ্যোতিয়ে মিতালীৰ মাক, ভায়েক আৰু গোচৰীয়াক শেষ কৰিম বুলি হত্যাৰ ভাবুকি দেখুৱায় আৰু মিতালীক পুনৰ পলাই যাবলৈ নিৰ্দেশ দিয়ে। সেই মৰ্মে ভাবুকি দিয়াৰ ফলত পুনৰ মিতালী 1 নং পদকীয়াৰ গুণজ্যোতিৰ লগত পলাই যায় আৰু এই কাৰ্যত 2 নং আৰু 3 নং পদকীয়াই তেওঁলোকক সহায় কৰে আৰু তেওঁলোকক নিৰ্ভয় দিয়ে। ইয়াৰ কেইদিনমান পিছত মিতালীয়ে গুচৰীয়াৰ শালপতিক নমাটি গাঁৱৰ বামুণবৰী চুপাৰী শ্ৰী শিৱপ্ৰসাদ শৰ্মাক ফোন কৰে আৰু 1 নং পদকীয়া গুণজ্যোতিৰ অনুপস্থিতিত মিতালীক গুচৰীয়াৰ ঘৰলৈ লৈ আহিবলৈ অনুৰোধ কৰে। সেই মৰ্মে শিৱপ্ৰসাদ শৰ্মাই গুচৰীয়াৰ পত্নীক মিতালীক লৈ আহে আৰু গুচৰীয়াৰ ঘৰত থৈ যায়। তাৰ পিছত গুচৰীয়া ঘৰত থকা অৱস্থাত গুণজ্যোতি শৰ্মাই গুচৰীয়াৰ পত্নীৰ লগত পুনৰ ফোন আৰু হোৱাটছআপৰ যোগেদি কথা বতৰা আৰম্ভ কৰে আৰু ঘৰৰ পৰা পলাই যাবলৈ কয় আৰু গুচৰীয়াক পুনৰে মৃত্যুৰ ভাবুকি প্ৰদান কৰে আৰু যদিহে মিতালীক ঘৰৰ পৰা যাবলৈ নিদিয়ে তেওঁক মাৰি পেলাব বুলি কয়। এনেতে হঠাৎ এদিন গুচৰীয়াৰ পত্নী মিতালীয়ে গুণজ্যোতিৰ সহায়ত পুলিচৰ লগত যোগাযোগ কৰি মোৰ ঘৰৰ পৰা পুলিচৰ সহায়ত কিছু টকা, সোণৰ গহনা আৰু 2টা মূল্যৱান কাপোৰৰ ভৰ্তি বেগ লৈ গুচি যায়। পিছদিনা টিহু থানাই মিতালীক টিহু আদালতত হাজিৰ কৰে আৰু টিহু আদালতে মিতালীক নিজৰ জামিনত যাবলৈ দিয়ে। গুচৰীয়াৰ পত্নীয়ে লৈ যোৱা সামগ্ৰীসমূহ হ'ল ফ্ৰেঞ্চ মিলত এ লং ডেছক্ৰিপশ্যন হেজ বিন গিভেন হুইচ ইজ এবছলিউটলি ফলছ মিলত। অন্যথায় আই এম স্কিপিং দিছ পাৰ্ট মিলত। অন্যথায় গুচৰীয়াক প্ৰাণে মৰাৰ ভাবুকি দি থাকে। বৰ্তমান গুচৰীয়াৰ পত্নী মিতালীৰ সৈতে গুণজ্যোতি শৰ্মাই গুৱাহাটীৰ লাল গণেশত ভাড়া কৰি দুয়ো একেলগে অবৈধভাৱে স্বামী স্ত্ৰী হিচাপে বসবাস কৰি আছে। তেওঁলোকে উক্ত কামত 2 নং পদকীয়া স্বয়ংক্ৰিয় সহায় কৰি আছে। বৰ্তমান গুণজ্যোতি শৰ্মা, ধীৰাজ শৰ্মা আৰু নৱকুমাৰ শৰ্মাই লগ লাগি গুচৰীয়াৰ পত্নীক লৈ নাৰী ব্যৱসায় কৰাৰ ষড়যন্ত্ৰ কৰি আছে আৰু অন্যথায় তাইক হত্যা কৰিব পাৰে বুলি মোৰ সন্দেহ হৈছে। লগতে মিতালীয়ে 20 লাখ টকা দাবী কৰে। ভৱিষ্যতে যাতে কোনো ধৰণৰ টকা পইচা বিচাৰিব নোৱাৰে তাৰ উচিত ব্যৱস্থা গ্ৰহণ কৰাৰ আৱশ্যক হৈছে আৰু যাতে গুচৰীয়াৰ 2 পুত্ৰ আৰু তেওঁক বধ কৰিব নোৱাৰে তাৰ বিহিত ব্যৱস্থা লোৱাৰ আৱশ্যক হৈছে। ঘটনাৰ সাক্ষীয়ে জানে ও প্ৰমাণ কৰিব। এতেকে মাননীয় মহোদয়ে এই 3 দুৰ্বৃত্তৰ কবলৰ পৰা গুচৰীয়াৰ ধৰ্মপত্নীক উদ্ধাৰক্ৰমে গুচৰীয়াক চমজাই দি উক্ত 3 পদকীয়াৰ বিৰুদ্ধে ভাৰতীয় দণ্ডবিধি আইনৰ 120B ছয়ঞ্চ ধাৰা মতে গোচৰ ৰুজু কৰি মোৰ মিতালীক মোক হত্যাৰ বাবে কৌশল হিচাপে ব্যৱহাৰ কৰি মোৰ পৰিয়ালৰ যাতে কোনো ক্ষতি সাধন কৰিব নোৱাৰে তাৰ উচিত ব্যৱস্থা লোৱাৰ কামনা আৰু ঘটনাৰ তদন্তক্ৰমে বিচাৰন্তে উপযুক্ত শাস্তি দিয়াৰ কামনা। So, my lord, this is a complaint that now the petitioner number 2 is also now before my lord, my lord, who is the Mitali Devi Pathak, and the petitioner number 1 is the accused number 1. Now, my lord, once this case has been, the cognizance has been taken, my lord, the statement of the petitioner number 2 had also been recorded by the learned, my lord, session judge. It has been registered as a session because, my lord, as section 366 is involved, my lord, it had been transferred to Nalbari session judge, my lord, and it has been ultimately registered as sessions case number 89/2023. Now, my lord, may kindly peruse the statement on oath given by the petitioner number 2, my lord. My lord, may kindly turn to page 41, annexure 6, my lord. Page 41, my lord. I know the complainant, Motor Pathak, who is my husband. I know the accused person, namely Gunojyoti Sharma, Dhiraj Kumar Sharma, and Nabo Kumar Sharma. I was married to Mothur Pathak in the year 2000, and out of wedlock, we had 2 male child. The eldest one is so-and-so and aged about so-and-so years, and the youngest is also so-and-so, aged about 17 years. Both of my sons are studying in so-and-so respectively. On 28/11/2022, after having quarrel with my husband, I on my own had left for Gujarat without informing my husband. Then I was recovered by police from Gujarat, and along with me accused Gunojyoti was apprehended by the police. After that, police produced me before Tihu court where my statement was recorded. Presently I am residing at Lal Ganesh, Guwahati all alone. It is a fact that, now cross-examination, my lord, may kindly peruse, my lord. It is a fact that I have staying in the hostel of the school where I am employed at Lal Ganesh, Guwahati. The said school is a private school. It is a fact that I have no allegation against the accused person of this case. So, my lord,
She is also an accused.
My lord?
She is also an accused.
She is also an accused number 4, my lord.
How she was examined as a PW1 or victim?
No, my lord, now it is the procedure has been adopted by the, my lord, this sessions court, my lord. That is the issue, my lord. And secondly, my lord,
No, procedure is different thing.
That is correct, my lord. That is correct. Once he is an accused, he cannot have been examined under this provision of law, my lord. There is a bar. Now, my lord, as he had been examined, the deposition of PW1, now the accused had been converted into PW1, my lord. And I have also, my lord, I have also brought into my lordship's kind notice to the array of accused, my lord, at page 34, my lord. Accused number 4 is herself, my lord.
Yes, I have.
That is yes, my lord. Now, my lord, as it is a statement on oath, my lord, there may be some, my lord, procedural discrepancies are there. But, my lord, as it is a statement on oath before a court below, my lord, which is an evidentiary value. So, therefore, my lord, we have brought on record this PW1 also, my lord, as her, my lord, evidence on oath.
No, but
now, my lord, another.
No. Question is different.
My lord.
It was sent for police for inquiry.
No, it has not been sent for police court because, my lord, we have annexed all the orders. My lord, may kindly peruse the earlier order.
When is there?
No, my lord, what has happened, my lord? What has happened, my lord? Before filing of the complaint, another FIR had been lodged. My lord, I have also annexed that FIR. Is at page, my lord, 22. My lord, may kindly, that FIR mention had also been made in the complaint, my lord. My lord, may peruse the vernacular part is at page 24, my lord. Proti Manonio Tihu Arokhi Sokir Bharprapta Bikoya Tihu Nolbari Apam Maki Baha Soyenso Bikoy Opoharan Karir Kobolor Pora Potnik Uddhar Korar Bhabe Abedan. Mohaha Hanman Purok.
This case was registered, also registered?
Also registered, my lord. Registered as Tihu PS case number 123/2022 under section 363 IPC. Now, my lord, the police when went for search, in this case, she was recovered, my lord. My lord, may kindly peruse page 26, it will clarify, my lord. Page 26 is her statement recorded, my lord, under section 161, my lord. As stated above, my name and address is true. My age is 43 years. I am housewife. I was married with my husband, Mathur Pathak, in the year 2000 on 12 June.
It was her statement.
Her statement, my lord. In her statement, why I am bringing my lordship's precious attention, my lord, because in this statement, my lord, she has specifically said that my lord, my husband is a teacher in Makibaha High School. We are not happy with our conjugal life. He inflicts physical and mental torture on me. My lord, may kindly appreciate, my lord, a married woman having 2 child has voluntarily, my lord, I am using the word eloped, my lord, with the accused number 1 under not normal circumstances. Such an action or such an act would be done by any normal human being. Obviously, my lord, there is some serious nature of, my lord, physical and mental torture had been inflicted. Now, my lord, as I had not been kidnapped, now we are as a petitioner number 1, accused number 1, I am facing a proceeding, my lord, which is not at all maintainable. Because the allegation is that, my lord, the petitioner number 2 had been kidnapped by me, my lord. That is not at all sustainable in view of the material which I have brought on record before my lordship, my lord. And therefore, if this proceeding is allowed to pursue further, my lord, then this will be a clear abuse of the process of the court of law, my lord. Therefore, my lord, in exercise of the power under section 482, my lord, this is a fit case wherein my lordship may, if my lordship is satisfied, can interfere, my lord. My lord, at this moment, my lord, as there are private parties are there, my lord, information is there, they are also required to be heard. My lordship may be pleased to issue notice, my lord, and in the interim, the further proceeding may be kept in abeyance, my lord. That is my limited prayer today, my lord.
At this stage, notice maybe you should let them appear, my lord. Whatever they want to say, my lord.
But, my lord, if the proceeding goes, my lord, it will be an abuse.
Otherwise, my lord, what they have, my lord, prima facie, my lord, what they have done, my lord, they would have first, my lord, get separated from each others, my lord. Anyway, my lord, that is a different aspect.
That is a different aspect of law, my lord, and the law is well settled by the Honorable Apex Court, my lord, regarding the living in relationship or the bigamy has also been, my lord, nowadays not more in force, my lord. So, therefore, there are no other section is attracted, my lord.
Live-in relationship, that my lord, decision is cited, that is, my lord, before marriage. My lord, between 2 married persons, my lord, that concept not comes in
my friend is correct, my lord.
If you go by the state, She also filed a thing
Yes.
there.
Let them fight
because
between themselves, my lord. First notice may be issued, my lord.
are you here?
Okay, sorry.
I did not know. 24. 24. Here we Waterfall. Issue notice. No formal notice issued by today. And also there is subsequent paid by the council president. And also considering the witness ability of further proceeding in. Now, what is the stage of the case at present?
My lord, it is in the evidence stage, my lord. Evidence stage. No? But the Lord, next date of hearing is on 16/8/2024. Is at evidence stage, my lord.
Complaint case number CR case number 2 of 2023, registered under section 180B, 566, 342 Act. Okay, it will be stated in the exit of listing and issue notice to the private respondent.
My lord, proceeding may be stayed, my lord. My lord, highly obliged, my lord. Next.
4.
Obliged.
Ma'am, so by this application, my lord, I am challenging the order which has been passed against me under section 143A of the NI Act, my lord, whereby I have been directed to pay 20% of the check amount, my lord. So that pays 36 is the order, my lord. My lord, 143A is not mandatory, my lord. It is discretionary, my lord. So no reason has been assigned why 20% has been awarded, my lord, against me, my lord. Page number 36 is that order, my lord. May I read? Both parties are present with the learned counsel. Today is each court order on petition number so and so. Heard both sides. The complainant have made a prayer before the court to pass necessary order directing the accused person to pay 20% of check amount as an interim measure to the complainant under section 143 of the NI. I have heard the learned counsel for complainant. On the other hand, the learned counsel for the accused has submitted that the prayer of the complainant under section 143A of the NI Act need not be allowed since there is dispute with regard to the said issuance of the check between the parties. Section 143A of the NI Act was introduced to protect the interests of both the complainant as well as the accused. It is beneficial for the complainant as because the complainant has suffered loss as a result of the accused not paying the dishonored check amount and hence payment of compensation to him as provided under section 143A of NI Act will go a long way in giving him monetary relief. It is beneficial for the accused also because as the amount already deposited in pursuance of the order under section 143A will be adjusted against the final order judgment passed against him, and if the judgment is passed in favor of the accused person, he is entitled for refund of the same from the company at the rate of existing rate of bank interest. Keeping
So
the
against that order, you have also filed a revision.
Yes, my lord. That has been. I am coming to that, my lord. Keeping the aforesaid discussion in the background, I am of the view that the instant case, being a summary procedure case, and the fact that accused have pleaded not guilty after impairing his appearance, the requirement of section 143 of NI Act is hereby fulfilled. Hence, prayer of complainant is hereby allowed. Accused is directed to pay 20% of check amount of 2 lakh rupees to the complainant within 60 days from the date of order. So why 20%, my lord? It may vary from 1% to 20%, my lord. So why the maximum has been chosen? It has not been mentioned. That reason has been not given, my lord. And in the revision also, I have challenged that, my lord, that this has been not given. But finally come to the conclusion, my lord, at the revision petition, my lord, where my petition has been dismissed. Page number 61, my lord. The revisional court has observed that, my lord, for allowing the 143A application, my lord, court has, the magistrate has, my lord, given reason, my lord.
But that is not the ground of challenge, my lord. Why 20%, my lord? That is the, to that effect, my lord, there is nothing, no comment has been made, my lord. Paragraph number 21, my lord.
So you do not agree by the order, suppose.
My lord.
And if you want to say that why 20%, it may be 10 or 15 also.
Yes, madam.
Why don't you file an application before that court that it may reduce? Because obviously you are saying that it's right that
Madam.
20% is the maximum step.
Yes,
Not
madam.
that if considering the facts and circumstances and the case of the financial position, etc., all and
Yes,
all,
yes, madam.
it may be reduced. There are judgments.
My lord.
So why don't you file a petition before the court below?
Court below, my lord, whether court below can recall its own order, my lord. It cannot be done, my lord. So, my lord,
Okay, now what is your prayer now?
my prayer is, my lord, only that order, my lord, which is under challenge, my lord, it may be stayed, my lord, the operation of that order. So I am relying on some judgment.
But the operation of that order, suppose,
My lord.
Is there any order in the last phase that subject to payment of so and so it will proceed and all? Is there any? I mean, the recovery of fine of 4 under section 421.
It has not been initiated yet, my lord. It has not been initiated. That's why, my lord. So apart from the kindly come to the petition filed by the complainant, my lord, there is no reason assigned by the complainant for preparing the application, my lord. Page number 29, my lord. It must show, the complainant also saw that he is suffering from financial hardship or since long this case has been pending, my lord. Nothing. Page number 29, my lord. Only 2 paragraphs, my lord. May I read, my lord?
No, no,
Yes, my lord. So in that aspect, my lord, I am relying on some judgment also, my lord. The first one passed by the Honorable, my lord, Madras High Court, my lord. Only come to last page, my lord, para number 18, my lord. LGR judgment, my lord. Para 18. May I read? A careful reading of the order passed by the court below shows that the court below has focused more on the issue of the prospective and retrospective operation of the amendment. The court has not given any reason as to why it is directing the accused person to pay an interim compensation of 20% to the complainant. As held by this court, the discretionary power that is vested in the trial court in ordering for interim compensation must be supported by reasons. And unfortunately, in this case, it is not supported by reasons. The attempt made by the learned counsel for the respondent to read certain reasons in the order cannot be done by this court, since the court is testing the application of mind of the court below while passing the interim order by exercising its discretion, and this court cannot attempt to supplement it with the reasons argued by the learned counsel for the respondent. So, the other judgment, my lord, that has been passed by the Jammu and Kashmir High Court, my lord. My lord, in that judgment, para 10, my lord, case 3 of that judgment, my lord. May I read, my lord? Although no guidelines for grant of interim compensation has been laid down in section 143A of NI Act, yet it is settled law that whatever a discretionary power is to be exercised by a court, the same has to be exercised on a well-recognized principle supported by reasons. The court has to spell out the reasons for grant of interim compensation in favor of the complainant, and it has also to justify in its order with reasons the quantum of interim compensation that is being awarded by him, as the said quantum can vary from 1% to 20% of the check amount. Next, my lord, it is not just...
Okay. Where? Probably around 29. You are Mr. UK?
H. Ali.
H. 58. Sorry, 29. Hard this is an application. BNS for education is Supreme for what Washington City inside of Interim order dated 8 2023 passed in CRP number 124 2019 by Learned NDPS number 2 Combo M 1, whereby the petitioner was directed to pay 20% of the check amount of the base 2 lakhs. Issue notice to the respondent to register to the NIG process and also call for the scan copy of the case. Submitted by Mr. Ali that the Learned Court below has not passed any written order while allowing the petition to pay, allowing the petition and directing the present petitioner to pay 20% of the check amount. Further, he submitted that there is no reason in the order as to why the compensation was given, 20% was given as a compensation under section 148 of the, under section 148A, 143 or 148?
143A.
143A of the NIM. He further submitted that because the state order, he also preferred a revision petition, but that has been dismissed by the Learned Additional Session Judge number 1 Kamuk M. Guwahati without considering the fact that the Learned Court below did not pass any present order while granting the 20% of the 20% of the check amount on the prayer made by the complainant. In this context, it also relied on decisions of Honorable Madras High Court, reported in 2019, Legal Eagle, MAP at Outer Packet of PCR 2734. Also relied on another decision of Jammu and Kashmir High Court, reported by 2020 as PDL 4148 JLK. It will be a High Court, right? According to Mr. Ali submitted that the further the state order may be stayed, the disposal of considering the commitment and other the operation of Urban Order dated 3/8/2023 passed in CRDS number 1224/2009 and implemented an order dated 26/4/2024 passed in Criminal Division number 68 of 2023 by Additional Session Judge number 1 Kamuk M. Guwahati with by state the next day. It means the matter accordingly after. You state and you take step for
well, obliged.
Complete the petition with a time limit.
Lordship, this is regarding a Zimma of Erica Nuts. Kindly peruse page number 12 for FIR.
I mean, who are you? You are the owner of
the Erica Nets.
And you are also an accused or no?
No.
You are also shown as an accused? You are also an accused in this case?
Yes, Lordship. Kindly report may be called for.
And your earlier order, is there any earlier order?
Yes,
Rejection
Lordship.
order?
Impugn order is there. We have filed an additional affidavit for that.
Rejection order?
Yes, Lordship.
Where is it?
We are challenging that impugn order.
No, where you have annexed the order?
We have filed the additional affidavit before vacation.
That means while filing the petition, you have annexed the order?
No.
It's not yet received.
Not yet received.
In the morning hours, you could have mentioned it.
No, Lordship. We thought it is supposed to be there.
No,
it's not there. Can you kindly...
That the order which you have challenged is not here, then how can this could be based on the key difference? Can be given. The listing on the 19th?
19th.
You just make first.
Okay, Lordship. Kindly open.
May I please, Lordship?
Yes.
As per the instruction of my client, I would like to withdraw this petition.
Want to withdraw? What is your name?
Ahad.
You are Mr. A. Ahad. Mr. A. Ahad. And as per instructions of his bank, it is submitted that he wants to withdraw the same. Submission will be realized. Present this certificate if you have at this post of computer.
Oblige.
May please, Your Lordship. So 438 application, my lord, case diary will be required. So my lord, can you please call for the case diary? Lordship.
Case diary will be
Case diary
required.
requirement. NDPS, my lord, intermediate quantity.
Okay. Yes, from when?
29th,
29th of this month. Since when he is in custody?
No, my lord, it's an AB, my lord.
AB. Oh, sorry,
AB, my lord.
29.
I'm deeply obliged, my lord.
May I please, Your Lordship? Serious bail application, Your Lordship. FIR at page 12, Your Lordship. This is a complaint was filed before the CGM, subsequently registered as PS case, Your Lordship.
Initially, it was a complaint case.
My Lord. Filed before the CGM court.
Under which section it is registered now?
420, 406, 506.
420?
420, 406, 506, 34. If Lordship kindly comes to page 12, Lordship, this is the complaint.
Achha.
And Lordship will find the relevant portion at para 3 at page 14.
Yes, sir.
Page 14 is the relevant portion, Lordship.
Para 3.
Yes, para 3, Lordship. Here petitioner number 1 is the accused number 1 and accused number 2 is the lot mandal, Lordship. So allegation is against the lot mandal as well as the petitioner.
I am not for the lot mandal.
Yes, here I am just stating, Lordship. Paragraph 3, Lordship, kindly goes to page 14.
Basically, the allegation is that they have,
The government has secured land. They have impersonated, Lordship, the complainant. That is the allegation, and withdrawn the
compensation amount.
Compensation amount of rupees 1 lakh.
Yes.
1,77,900. Yes, I have withdrawn, my lord, against the land possessed by me. Owner and possessor is the present accused petitioner. Against
You are the owner and possessor.
yes, your lordship. And my dwelling houses has been were standing over the land, and this land is acquired by the government by following all formalities, your lordship. This is the case of 2016, your lordship. Since the year 2016, no such complaint was raised by the informant, your lordship. The fact is that, my lord, land acquired by the government.
Received the
Both,
compensation amount in 2016 only.
no, my lord, land was acquired
23.
and
On 23.
one case
5/9/23.
case was registered. Land acquisition case was of 2016, your lordship.
Yes.
My lord, actually land is acquired adjacent to the present petitioner. Land of the informant is also acquired. They have also received the award, but only with intent to harass the present petitioner, this complaint was filed, my lord, and nothing else, your lordship. Moreover, my lord, the allegations raised by the informant is purely civil in nature. They are now, my lord, their allegation is that the land which is acquired by the government, against which I received the award, my lord, that land is there, belongs to them, your lordship. So, allegation is civil in nature, your lordship.
There are some other forums also
My lord.
raised to this.
And yes, your lord.
But the allegation against you
And
that you
impersonated.
impersonated some other one. Claim yourself to be the owner. As per allegation.
My lord,
Not
as
the
per
owner.
allegation.
Lordship, their bail was also rejected at page 18. Lordship.
Page
18. 18. Lordship.
Considering-
Perusal of the case diary. Lordship.
Okay.
Considering the early stage of investigation, bail was rejected, your lordship.
Then let us see what is the stage of investigation at present.
I will appear before the investigating officer, my lord, and I will submit the land-related documents also, my lord. I will cooperate, my lord.
Card is that K. Rahman and counsel for the petition. That petition appearing on behalf of state respondent. It's their application. You have filed this application when?
28/6.
6 in June. June.
My lord.
Under section 438 of the CRPC. Praying for judge. It is submitted by Mr. Rahman that he is the owner and possessor of the land which was acquired by the government, and it is the fact that on acquisition of the land he received the compensation award from the government. He further submitted that the adjacent land belonged to the informant that complained, and he also received a compensation award from the government, which was registered in the year 2016 as land acquisition cases. But the present petitioner was harassed by the complaint by launching a false and concocted case against him. However, he is ready and willing to cooperate and in further of his case if he is granted the privilege of interim review. Mr. Sharma, in an additional repeat submission that it is that the as per the allegation of the present petitioner impersonated himself to be the owner, less complainant, owner of the land, and in connivance with the other accused person, he received the awarded compensation from the government. Accordingly, he insisted to call for considering the submission made by the council for the outer other service, the submission made by the Government Council for the finding that it's in the privilege of interim okay, you'll be under interim protection.
Right.
CDB call for CD Sharma.
That's it, 5th of August.
5th of August.
I will appear before the
5th of August. Within 7 days, you appear before the IO cooperative union.
I know. Oblige, Your Lord.
That is a lesson.
Yes.
So I want to wait to discuss that.
We want to withdraw.
Yes, yes.
You are Mr. G.U.D.
Okay.
Same order. Instruction of withdraw. Okay, it will be disposed on withdraw.
May I please note?
Yes.
My lord, page 7 is the FIR.
Page 7.
7. Lordship, this is the FIR dated Lordship 6/2024. Lordship, may I read this contents of the FIR. We disrespect the informant that we state that in the year 2009, Lordship, this is important, Lordship, 2009. The below noted accused person jointly opened a financial institution in the name of so-and-so at Borobazar and collected money from the informant and 2,000-3,000 people of Borobazar area for the purpose of keeping the money as daily, monthly, annually, and fixed deposit at the rate of interest of ₹6% per annum. It is regret to say that as per norms of Sanstha, the same amount ought to refund after a stipulated time period to the customer, but they failed, and for which the customer approached the accused to get information about the refunded money. But sorry to say that when the informant and the customer approached the accused instead of giving response has made them fatally. Well, this is the allegation, and so far this allegation is pertaining to the year of 2009. And list of lordship accused is given, that is your lordship will find page 13. And two petitioners lordship here. Their names lordship appear at page 14. Serial number 24 and 25. And in their designation, your lordship will find they have been designated as ex-member. In fact, lordship, at that
For ex-member for which organization?
For that organization, lordship, that is reflected in FIR lordship. That is Himalaya Socio-Economic Development Sanstha. This is the list lordship they have annexed with the FIR. This is the part of the FIR lordship. 24 and 25, the present petitioner lordship. Look, this FIR lordship is filed only to realize the money lordship that has been appeared in the FIR itself lordship. Look, if it is for realization of money, whether this case can constitute a criminal offence lordship. And that apart lordship, this is the allegation was pertaining to the year of 2009. May I pray lordship at this instance, your lordship may protect us, we will cooperate with the investigation and CD may call for lordship.
So only CD at this stage. The allegation is lordship misappropriation of money lordship. Around 2,000 or 3,000 people have deposited money in the promise of returning with daily interest lordship, but that has not been paid. Let the CD come look.
Only one lordship has passed. FIR has lost by one person. And that lordship up in the year 2024, 6/2024. Allegation was 2009. They can file a civil suit also lordship for realization of money with that. In fact, lordship, the present petitioner lordship, they were at that time lordship part-time employee lordship. They just get a lordship, collect money from the registered customer and deposit the amount to the company lordship. And that company was lordship also lordship closing down their business lordship prior to COVID-19.
Only CD lordship.
And if my humble some protection may be given lordship. We will cooperate with the investigation lordship. The next day, if your lordship found that materials are there, your lordship may reject it. But These FIRs appears that this is a civil dispute. Only to realize the money. 420 cannot attack in this case, Lordship. There was no allegation of decision from inception, Lordship.
Only CD, Lordship. A huge amount of money is involved, Lordship.
Where is the amount of money? There is no amount of money has been mentioned in the FIR also, Lordship. And how much, Lordship, money was collected from the informant itself, that has not been, that also, Lordship, has not been reflected in the FIR.
Heard Mr. M. Khan, United North India, and also heard Mr. B. Sharma, United sections 20. It's submitted by Mr. Khan that the petition and no vacancy. Also, the case was the incident had happened in the year 2009, and the present FIR has been filed on 6/6/2024 after the lapse of almost 50 these two petitions are also known as an ex-member of the nation. The verdict submitted that this is the case only for the recovery of money, and they can very well approach the forum for safe recovery of money. However, if the petitioners are ready and cooperate the island in further investigation of this case, if they are granted with the privilege of interim period. In this context, Mr. Sharma done is submitted that it is the case where the huge amount of money has been misappropriated by the present expedition along with others. They have already collected the money from about 2,000, 3,000 people with an assurance that the money will be returned at the rate of 6% per annum. Accordingly, that the city will be required to know the exact fact of the case. Mr. Khan submitted in this context that there is no mention about the misappropriated money in the FIR, nor there is any names of the victim or and as to what amount the petitioner was misappropriated. Next one, considering this submission made by the proposals, other aspects of the case, I find it necessary enough. Okay, we are under interim protection.
Good.
That can be given. Yes, Mr. Sharma.
Lordship, 5th of August.
Masam.
May I please your Lordship? 482 bail application, Lordship. Allegation under 379, Lordship. Lordship, FR is phase 15, Lordship. 15, Lordship. Particular, Lordship. Lordship, one accused person, namely Didar Ali, Lordship, arrested, Lordship.
Lordship, I'm sorry, Lordship. Here, Lordship, they have made Union of India the party, Lordship. Lordship, it should be asked, Lordship, because this is GRPS, Lordship, Guwahati Railway Police, Government Railway Police case, Lordship. So it falls under our jurisdiction, Lordship. But they have made the party Union of India, Lordship.
Oh.
So they will have to file it afresh, Lordship.
Why you have made Union of India? If it is under GRPS?
Lordship, Kamakha GRPS.
Yes, obviously Kamakha GRPS. They tell by
yes.
PP most probably.
Yes.
We are listing it on 18th. 18th. You file an additional affidavit correcting the name of locally listed. We hear them at that, we will try. On 18th.
18th.
List on 18th.
May I please, Your Lordship? 430 application, Lordship. Allegation here in this case, Lordship, 492 number of telemetric cable lost from the godown of the informant, Lordship. And petition is not naming the FIR, Lordship. Is the electrician of that company. And it on page 10 is the FIR. May I read, Lord? I am writing to report the loss of 492 number of telemetry cable, especially used in the seismic survey for oil and gas exploration survey. For our godown located at Rupai warehouse at Tinchaka district, the incident came to our notice on 26/4/2024 at 13 hours when our company representative visit our site, and we believe the loss occurred between 22 March 2024 at 932 and 12 March so. And the telemetry cable are crucial for our operation, and their loss has caused a significant disruption in our work. We have conducted an internal inquiry and have found theft persons in the CCTV footage and enclosed here with CCTV footage record. During investigation, the concerned police arrested 5 persons, and I have annexed the forwarding list of the 5 accused persons. Highly on page 12. Ground of arrest. Married Lordship. Page 12 is the. During investigation, the accused person Sunil Sharma confessed his guilt that he, along with Sangeet Tanti, Sri Vikas Karmakar and Body and his son, entered into godown and stolen the wire and FDI and loaded the same in vehicle of Sri Vikas Verma and Raju Pradhan. The petitioners are not in the petition is the Hamidul Islam. He is the electrician in the of the Devi Engineering and Construction. And they took the vehicle to Namirin, Tinal and Sunari respectively. Later accused persons Sangeet Tanti, Vikas Karmakar and Body and Vikas Burman and Sri Raju Pradhan were apprehended in connection with the case. On being lead and shown by Sri Raju Pradhan, the accused person Moram Ali Loskar alias Papu was apprehended. From the possession Moram Ali Loskar and Papu, 4 bags of oil were recovered from Halunting, 7 bags of oil recovered from Mathurapur and 17 some of FDI recovered at Suna. All the materials are already recovered. I have annexed the seizure list also. The material lost material are recovered from the one Moram Ali lost scholarship. That is for page 14 is the seizure list. Nothing was recovered from petitioner is the electrician of that company. Now the police calling the petition, he may only suspend the petitioner may be involved in this. At this kindly case may be called and in the meantime I may be protected. I will appear before the IO lordship and record at my.
If he is an electrician lordship, he has no apprehension lordship.
Now
there must be something lordship. It will be required.
It will be required. He is not a
Lordship, there is nothing, and thereafter all the accused are already released on bail by the Lanet court below. I have the order copy also. Lordship.
We are calling for the case then.
Till that, Lordship, I may be protected.
Your petitioner may be innocent. We are not on that.
Lordship.
Your petitioner may be innocent because he may be a victim.
I will cooperate the investigation. Lordship. Investigation almost complete.
These things are going on for a last 7 years in fact.
Lordship.
Now the FIR has been dropped.
All the accused also released on bail, Lordship.
Where from it has come?
From Tinsukia, Lordship. Tinsukia, Dumduma, Lordship.
That benefit can be fixed.
Short date can be given on 23, Lordship.
Here is the Lanet court bill order. All the accused are already released on bail by the Lanet court bill. Finally, till that I may be protected, Lordship. Yeah, all the arrested factors already released on bail. I may be protected, Lordship, till that, Lordship.
No protection. Yes, we are fixing it on 23. Yep.
कितना मिला?
23.
हाँ सब लग.
Really sorry. No, it's a second application, my lord. On the first occasion, Your Lordship appreciated the city and rejected the bail application, my lord. It was on that particular day, my lord, it was under section 438. Now it is under 482, my lord. Under this Bharatiya Nagarik Suraksha Samhita, my lord. Now, one specific reason, my lord, for filing this, otherwise I wouldn't have insisted my client to file it, my lord. Paragraph 14, page 8, my lord. Page 8, my lordship. That it is pertinent to articulate here that the accused petitioner got married about 6 months back, and his family, comprising his wife and aged mother, who are mentally and financially dependent on the accused petitioner. Because of apprehension of arrest, the accused petitioner, irrespective of the fact of his innocence, could not be able to take up bare minimum care to his ailing mother and the wife, and in consequence, the mother and the wife of the accused petitioner have fallen seriously ill, needing urgent medical intervention. During preliminary examination by a doctor at Bongaigaon, it was found that the mother of the accused petitioner is urgently required to visit a nephrologist from a super specialty hospital for further investigation and the treatment and the wife, to be precise, who is also under supervision of a doctor due to certain endometriosis and in requirement of specialized treatment. So the prayer is, in view of the aforesaid circumstances, the accused petitioner has utmost sincerity approaching this honorable court, my lord, for the second time for consideration of his application filed under section 480. My lord, the offence, your lordship, is quite clever, my lord, 13 and 14, and more importantly, section 420 was earlier, it was included, and on that particular day, my lord, the PP has also said that may not be there because there is absolutely no chance. Well, this is a very limited prayer, my lord. Whatever conditions been imposed on the armed day, the only issue is this: I'm the lone fellow, I have to take care of mine, and that too very pretty offence, my lord.
Let us see the progress of the investigation at this case. Otherwise, the ground is, it's not a ground.
CD,
anyway, we are calling for the CD. It's though it is not set, but still we are calling for the CD. Let us see if there is any progress. Your petition may be considered.
And more importantly, my lord, all other co-accused out of the same affair already paid. The lordship has already gone through. And there is absolutely, my lord, to me, very limited knowledge. There is absolutely no record.
When you
lordship, 24th, lordship.
24th.
24th. Can it be a little earlier? It is the earliest date, lordship. 24th.
Okay.
No problem, let's stop.
Yes.
Lordship, pleases. In terms of the previous order, there was an amount which was pending that now stands complied. So the entire amount as mentioned in the MOU now stands paid. That's a statement I think which the complainant will have to verify. And if your lordships remember, the bail which was rejected by your lordships has now also stands allowed. I have the order of the Supreme Court, and in that it specifically mentions that the matter stands settled. I'm just passing this order to your lordships, rest the complainant will verify. But in terms of our instructions, the money has been paid. So on the last occasion, your lordships has already recorded in the order 4 point something was already paid. Now the remaining amount also stands paid. That, your lordships, was last listed on the 20th of June.
Mr. Nayak is absent today?
Yes, I think he's preparing for the informant.
Yes, because...
my lord, in this matter, earlier learned PP appeared in this matter regarding, my lord, whether those amounts were received by the party or not, my lord. I will have to get the instruction.
Yes, we have to take instruction, otherwise Mr. Nayak was there for the informant.
Yes,
but now he is absent.
Yes.
If we have completed, then can we fix tomorrow or day after tomorrow? Tomorrow it can be fixed, otherwise.
I'm in a slight difficulty tomorrow. Can it be day after if it is not inconvenient, your lordships, or a Friday?
day after tomorrow or Friday.
If it is not inconvenience to your lordships. Otherwise, tomorrow is fine. We will. If
Day after tomorrow,
we
Friday.
will second tomorrow, okay.
17 15 17
Let it be fixed on day after tomorrow.
Yes, madam.
I'll be grateful if it is.
And if Mr. Naik can be informed, or you can take instructions.
Yes, madam.
Whether they, as per them, on the last order also it is there that
Yes.
4.65 crores has already been paid.
Yes.
And in that process also 6.6 was there.
Yes.
And now they are submitting that 6.6 is already been.
I've submitted a chart also, your lordship.
Yes.
They-
Yes.
Yes.
Yes. And in the Supreme Court, what you have said?
In that, your lordship, that bail application has been now. Just, I'll just give it to your lordship. One. I think I already have submitted. To your lordship. Yes, in that it specifically records that the matter stands settled between the parties. In the first paragraph itself, case particularly fact that the appellant is a lady and the matter has been resolved between the informant and the appellant. So this was one of the bases on which the bail was granted to this. So I am under the impression that the money must have been paid.
So we are fixing it on day after tomorrow. Let us
Grateful,
see.
grateful.
List on. Yes, 17th? 7th. List on. We're fixing.
Grateful.
I should kindly peruse the last order of this. I should kindly peruse the last order of this honorable court.
As per my instruction, in this case, my lord, search sheet submitted, madam.
84 days behind the bar, lordship.
Search sheet submitted on 35/24, madam.
Search is submitted on
35/24. CS number 50.
35/24.
Yes. CS number 50/24.
I was appointed as the amicus curiae by the Honorable Court Lordship for the informant.
Yes.
Actually,
You are Miss
application-
Pooja Agarwal?
My lord, Dr. Pooja Agarwal. Lord, if your lordship kindly peruses paragraph 4 of the petition.
No, it's okay. Now, these are things that this case has already been charged sheeted.
My lord.
Let the trial court see the matter and then... if
False
any-
submissions, contradictory submissions are being made before this honorable court, my lord.
Okay.
In the anticipatory bail application,
Huh.
the petitioner had come up with a plea that the victim eloped with the petitioner. Now, in paragraph 4 of the instant bail application, they say that there was a misunderstanding on the base, and the FIR was lodged on the basis of a misunderstanding. Petitioner says he had gone to Siliguri, victim had gone to Kolkata, and thereafter the victim herself returned to her parents. Whereas the CD, which was produced before your lordships at the anticipatory bail stage, there it is found that the victim was rescued from Malda. So these are two absolutely contradictory statements being made before this honorable court.
Yes, obviously.
That was the version of the maybe the version of the victim lordship. But so far, our stand is concerned that we have taken.
No. She is not on that.
Petitioner's
She is saying that you have made, contradictory statement in different stages. That is her subject.
My lord.
Take one stand. It's okay. You can take your stand. They will definitely take their own stand, but they don't make any contradictory stand. That is their answer. Anyway, case is already charged.
Yes,
We are
sir.
going by the merit of the case at present. I heard Mr. M. Khan, the learned counsel for the petition, and also heard MS Pooja Agarwal, the
Dr.
learned.
P. Agarwal, my lord.
Pardon?
Dr. Pooja Agarwal.
Oh, sorry. Heard Dr. Pooja Agarwal, the learned amicus curiae appointed on behalf of respondent number 2, and Mr. P. Potter, the learned additional deputy appearing on behalf of state number 1. The submitted merits report that the case has already been charged in IPS 50 of 2024, dated 30/05/2024. Full stop. In this context, Dr. Pooja, the amicus curiae, also submitted that the accused petitioner took different stand on in different applications. Contradictory stand on at different stages of this case. However, as the case has already been charged, we can decline to discuss on the merit of the case, and the present petitioner is hereby asked to make appropriate application before the learned court below.
Special judge.
Maybe learned special judge.
Special judge.
Learned special judge, who is the?
Bongaigaon, Lordship.
Learned special judge Bongaigaon, which may be considered in accordance with law. With the above observation, the right is
Right.
okay. It is disposed of.
All right.
Lordship, in this matter, affidavit in opposition has been filed, and thereafter we have also filed in reply, Your Lordship, that we have filed today. Same are not on record, Your Lordship. So I pray may come up on some other day, Your Lordship.
Your reply is not on record.
Your Lordship, both affidavit in opposition and reply both are not in record, Your Lordship.
Oh, you have also filed your affidavit.
Yes, Lordship.
Why it is not on? Due to holidays, most probably.
Lordship,
not on
and the reply we have filed today, Your Lordship.
Today? Oh,
okay.
Achha.
May come up on any hearing day, Your Lordship.
You are Mr.
S.A. Hussain.
Hard Mr. S.A. Hussain, the learned counsel for the North of Artemis and Seka, the learned counsel, appearing on behalf of Mr. Kyle, the learned standing counsel. It is submitted by Mr. Hussain that the both the affidavit in opposition and the reply filed by the petitioner is not on record. Accordingly, they state they have been directed to check the affidavit in opposition as well as reply. Full stop. List the matter accordingly at a hearing date maybe 25/7. 25/7 will do. Or
Prior to that, if possible, convenient to Your Lordship.
23 lots are there. Next Thursday, given take place. But 18 is also full. Huh? 23 is not possible, I think. Huh? 23 is. Can it? 23 can it? 23.
Lordship, much obliged.
Highly obliged.
List on place.
May I present the Lordship? For 39 bail application, FIR based claim. Lordship, the accused arrested on 14/4/2024, 93 days behind the bar. Lordship, the statutory period is over. So I am praying for bail, Lordship, considering the length of the petition.
Yes, well, case there is available, charge not yet filed. 92 days, you will
93 days, yes,
default bail. Otherwise,
6 box was there. Still, affidavit is now not.
charge not. 376D and 6 of box.
You are Mr.
Arya Ahmed.
Mr. Arya Ahmed, that is not for the petition. Mr. K.K. Bharat, that is petition PPA because on the application sector selection. It is submitted by. Since when you were in custody?
93 days behind the bar. 14/4.
14th of April.
The accused is behind the bars in plus 93 days and he was arrested
The default bail
on
for
24 and hence considering his active detention, he may be advised on guilty. Mr. Bharat submitted in this regard that on inquiry made by him and probably is that seen that the IO has not filed, the IO has not submitted the charge sheet even after that of the statutory period. Considering the submission made by the London Council for Instance, and also considering the fact that the IO failed to participate in that charge sheet even after the lapse of the statutory period, I hereby allow the petitioner to go on bail, considering the length of the day to the party satisfaction day. Where it is
Additional Session Judge Gleshwara.
additional just because of part. Put some you are allowed to go.
My lord, 47 charge sheet submitted, my lord, under section 21A and 22C of the NDPS Act.
Under section?
Charge sheet number 29/24,
24,
dated 30/6/24.
23.
Yes.
24.
30/6/24. Under section, my lord, 21A and 22C of the NDPS Act.
Yes. Okay, then. So we have
The case was registered under section 22B. Intermediate.
Your lordship may kindly go through the order of the learned trial court, rejection order, my lord.
My lord, after.
And now, my lord, charge sheet submitted under section 22C of the NDPS Act.
Within the time period or not, that part to examine. Because case was registered initially 22B, my lord. So the 90 days is the 60 days was the statutory period.
No, we cannot give you now because it is the 22C now. It is 22C now, and the order specifically reflects that it is 22C.
Yes.
But order, my lord, there is some puzzling because the learned judge mentioned here case was registered under section 22C.
Yes.
In fact, if it was added, my lord, the added order, my lord, we could not find out in that record, my lord. And case was registered under section 22B, not C. In the order reflect it was registered initially C. But whether typical mistake or other problem is there not clear.
That we cannot say
Yes,
because
but
CS is already filed under C.
22C.
But
So
why,
we have to go
suppose
by
my lord, a case is registered under section 22B, that is called intermediate. So 60 days is statutory period. If the my lord, after the statutory period, my lord, the C may become, but he will get entitled to the default bill, my lord.
Issue in the your code below, but
But
how can we say?
after the statutory period, my lord, it was filed, my lord.
Within the period of my statutory period, my lord,
It is 36, then after 60 days.
22C 90 days, my lord. So 180 days may be extended to 180 days, my lord. Within the period, my lord.
So my submission is that 22B
Let them
is the
submit
case.
all these things before the trial court, my lord.
Trial court you have to submit all. Otherwise, we don't have any.
Yes, my lord. Trial court will go through the materials.
CS has already been submitted
Okay,
to
got it.
22C section. So at this stage, we cannot say.
Yes, my lord. Trial court will go through the materials on record, my lord.
But one thing is here, my lord, while any case
Let
will
him point out
register
everything.
under a particular section, so my lord, the section concerned, the statutory will be
I don't know
counted.
at the time of investigation what had happened.
But they have filed, my lord, investigation agency. Those she has
the order. If you go by the order also.
my lord, the statutory period, my lord.
I don't know. If you
So
go
he is
order itself,
entitled
it
to
is-
get the default bill, I think, my lord. Because the initial register, my lord, is only 60 days.
That I don't know. That we cannot say at this stage. Hard Mr. Anuddin, the learned counsel for the hard district report. The learned district PPA on the respondent. It is submitted by Mr. Bott. That case has already been charged by CS number 29 of 2024, dated 30/24, under section 1C, 21A and 22C, capital C, NDPS Act. Also take the fact that it has already been done. It is hereby asked to file appropriate application for the learned trial court, which may be considered in accordance with the above observation. Present being if it is there, then you can make submission or you can raise
Yes.
issues, because It should not be, but from the order and from the charge sheet, it is 22C only.
Yeah.
So at this stage, without having anything, we cannot say. Disposed of. Okay.
Obliged to.
Whatever have you seen? It is 22C only.
Yes, madam.
Charge sheet is 22C.
Yes.
Now
The charge sheet, yes, my lord. My lord, after going to the my lord, file record, my lord, I, my lord, instructed from our office, my lord, get the, my lord, report, and my lord, thereafter they send this, my lord, number along with the charge sheet, because, my lord, one of the ground they have taken that case is registered under section 21 and 21B. Thereafter I have also gone through the trial court order, and thereafter, my lord, telephonically, my lord, I get this information from the IO, my lord, today itself, my lord, that under section 21.
Let's suppose even if it is, suppose in any case it is 21 or 22B, suppose.
Yes, ma'am.
In that case also the rigor of section 37 will not follow, then he can apply for it.
Yes, ma'am.
Okay, now 48.
Okay.
Yes, 48, yes.
May I please your lordship? Lordship, 439 application, my lord. 48 days as on today, my lord. My lord, annexure 1, page 9 is the FIR, my lord.
Okay. CD, my lord, page diary not received, my lord.
My lord, it's been
okay.
Long, my lord.
It was shown arrested on 25/24.
Yes, my 48 days as on today, my lord. Annexure 1, page 9 is the FIR, my lord. Because there are on 2 occasions, my lord, that is called for, my lord. He is behind the bar, my lord. My lord, annexure 1, page, my lord, may I?
The nature of case is a bit different. What about the CD? Why it does not come?
My lord,
has earlier record also.
My lord might remember around 4-5 months back there were a series of cases with regard to this on the call of the SP Lakhimpur. At that time, Anand Mishra, all the persons were directed to surrender, and as such, a huge sum of people surrendered before my last. My lord, if might remember that around 6-7 months back there were a series of cases with regard to fake goals. There was a call from the SP Lakhimpur, my lord, Anand Mishra at that point of time, that those persons involved with the racket of fake goal or those who had been on earlier with associated with those, they were directed to surrender. And as such, huge flock of persons, huge persons, thousands of persons have surrendered before the police. And multiple bail petitions have also come before this honorable court with the same series. And this person earlier was to be involved with those set of them, but presently he is not there. On that association, he has surrendered at that point of time. During his stay and grant of bail, my lord, this FI also it came into it, in which he was shown arrest, my lord. And my lord, here, so my lord, here I am praying with regard to the length of detention, my lord, 60 days offence, my lord, 48 days as on today, my lord. He is a permanent resident, and he was shown arrest only because he has surrendered with regard to the earlier cases when the call was made, my lord. Huge persons, my lord, my senior friend might remember that case also. Huge persons, my lord, series of cases came before this honorable court with regard to surrender before the police. So, my lord, he was earlier associated with the crime, but presently he was shown arrest in this offence. He is not involved in this offence, and my lord, if perused by the FIR also, the genuineness of the FIR is also a doubt also, my lord. And moreover, my lord, he is a local resident. He has served 48 days, my lord, and 60 days offence, my lord. 60 days offence, my lord. So 48 days, my lord. This length of detention
be said that, my lord, genuineness of the FIR is a doubt, because, my lord, this type of offence, your lordship, the similar kind of offences, my lord, continuously going on the same kind. My lord, here also the informant is from Mumbai, my lord. He is a resident of Mumbai. So the modus operandi of all the cases are same, my lord. How they, my lord, collected the details of these persons from various social media. Thereafter, luring them in providing my lord goals. Thereafter, when they came along with money, maybe not in this case because CD is not available with me. Thereafter, when they come, initially they looted those money from the my lord victimized person. Thereafter, my lord provided my lord fake gold. This type of offences, and in same area, Laluk Lakhimpur, my lord, your lordship, whenever about this.
Yeah, my lord.
And they also, my lord, factories for preparing all these fake golds, my lord, in those areas. My lord.
My lord, here I am also with the point of length of the
Same
60 days
kind of
offence
offence,
and 60 days of my lord, 48 days.
Your petitioner is a FINM accused.
FINM accused, my lord.
Here in this case, Son arrested on 28/5/24.
48 days on FINM accused, my lord.
There's shown arrest on 28/5.
28/5.
In earlier, which case you were there? Probably.
Son arrest,
Shown arrest, my lord, that
my lord, page 16, my lord.
Page 16.
Son arrest.
Son arrest with regard, my lord, another Bipuria PS case number 48/24. I was behind in judicial custody with regard to that case. My lord, with regard to the fake goal only, with regard to the that case, on the call, my lord, many persons have surrendered. He was one of them, and he was behind the bar at that point.
Yes, what about we are able to.
My lord,
it is CD within 4 or 5 days. It will be possible. Otherwise, he is on 48 days. I think. We can give you a date.
Any short date, my lord.
Friday.
Friday, I will try. Not Friday, on Monday, I will try to get it. Monday or Tuesday, my lord.
Monday can be.
Monday.
Yes.
Call to reminder, call for the case. Otherwise, it's okay. You have
Monday. Yes, my lord.
Yes.
Yes, my lord.
But the case is that it's only FINM.
Yes, my lord.
These are all habitual of doing same kind of
And the persons who, how they come,
No,
what is goal, kind of.
they are also, my lord, in a sense, my lord, it can be said that they are also a part of the, my lord, all these kind of offences.
Okay.
Because ultimately, when they come and fall
Go
along with those persons, later on they file this.
Yes, 10 grams of gold plus 24 carats of ready. It costs 70.
Then after
how can they come?
Yes, after getting those fake gold, they will sold it to some other person. Yes. They will cheat some other person somewhere.
Otherwise, how we cannot go to purchase the both shaped gold, shaped now.
Jesus Christ.
Yes.
Otherwise, all are criminals.
Yes, they are
all and
they have lost the FIR, but they are also
same them because they come with huge amount of money as per their own version. 3 lakhs, 4 lakhs, 7 lakhs, 14 lakhs.
And they well know that within that amount of money, they will never get pure gold, my lord.
No, not at all.
Oblige, my lord. My lord, on Monday?
Monday, yes. Monday is which day?
Oblige.
22nd of.
My lord, oblige.
You should remind that.
May it please, Lordship. My Lordship. 439 application in Lordship. Arrested on 19/5/2024, Lordship. As on date 59 days, Lordship. Earlier CD was called for, Lordship. CD was, Lordship, also. Earlier CD was called for, Lordship.
In this case,
and CD came and perused also, Your Lordship. But the thing is that, Your Lordship, CD was again sent back, Your Lordship, along with because that day 164 statement was not there, Your Lordship. So again it was sent back, Your Lordship, along with 164 statement. I think so far information derived, Your Lordship. Today CD is not.
CD not received, my lord, along with 164 statement, my lord. POSCO is also there, section 376(3), my lord. 164 statement is essential, my lord.
Oh, it's a very essential.
My lord.
So since when he is in custody?
59 days, Your Lordship. 59 days, Your Lordship. And so far my knowledge goes, Your Lordship, other day, Your Lordship. From the recital of the, Your Lordship, the 161 statement, Your Lordship, it appears that she developed love affair with the, Your Lordship, petitioner, Your Lordship.
Okay.
And since the 165 statement been recorded, Your Lordship, and that's why it was called for, Your Lordship, along with the case day, Your Lordship. So
any intimation
only
from the IO?
Yes, my lord, I will get the
intimation. You have received any
no, my lord, I have not received any intimation.
Lordship.
For the informant?
Yes, Lordship. I'm for the informant, but till moment I have not filed Ukalat number, Lordship. Today I have just received the Ukalat number. I will file it during the process of the day.
You are going to file?
Lordship.
Yes, Deva.
59 days, Your Lordship, considering the length
Now
of detention.
see, it's a case of POXO 4.
POXO, Your Lordship, the notice was served, Your Lordship, and accordingly, he did appeal, Your Lordship.
Without presence of the case diary or
20 days offense, my lord.
The case of 4 POXO is not possible on our part. Hard administrative one, that of and not hard administrative one, that and you are Mr.
A.K. Azad.
A.K. Azad, done on behalf of the that's response number 2. However, he submitted that he filed his Ukalat number. Mr. Bordopur submitted that on last occasion, CD was received, but however it was returned back, calling updated case diary along with statement of the victim girl under section 164 CRP. But the CD along with the statement of the victim not posted. To remind them, yes, as the cases not again. Yes, Mr.
On 37 minutes. Or 29/7 minutes.
Lordship, before that may kindly be fixed, Your Lordship.
Before that,
Lordship, because of the fact that if in the meantime, Your Lordship, to be transparently submitting before Your Lordship, in the meantime, Your Lordship, if the charge sheet been submitted, Your Lordship, then I'll again be confined, Your Lordship. Because then they would get the opportunity to file the bail petition, appropriate petition out there in the lower court, Your Lordship.
Can it be?
So maybe
one more 24/7 then.
Thereafter we cannot see 24/7.
Lordship.
Yes.
Oblige, deep oblige.
May I please, Lord?
Yes.
My lord, 50, my lord, charge sheet submitted in this case.
Charge sheet submitted.
My Lord, may I pay for calling the LCR Lordship?
Charge sheet is already submitted.
Yes, Lordship. Therefore, I am praying for calling the LCR Lordship.
No. Your bail petition was prior to filing of the charge sheet. Now why are you calling for the case?
As the charge sheet is submitted, I am praying so, Lordship.
No. It will be disposed of. Later on you can submit otherwise.
Otherwise,
The
84
same
days.
petition it was under 439 and now how it again call for the case, call for the case diary in fact.
Yes.
Was it a case of calling case record? No.
No, Lordship. CD was called, Lordship. In the meantime, she has submitted. Therefore, I am praying for calling the case diary, Lordship.
No, God.
Already 84 days in custody,
POXO,
Lordship.
6 POXO.
Yes, boss. POXO 6 is
Heard Mr. Rahman Hussain, returned also for the and also heard Mr. Nabi Body submitted by Mr. Body. Yes, Botakur, what is the
My lord, CS number 56/24, dated
54
35/24.
35/24. If you suppose don't get bail to the current court below, in that case you either
Yes.
you can approach this court. In that time, definitely will call for the case, but not at this case. It is
I was praying, Lordship, as I am 84 days in custody already.
yes, obviously. Obviously, you are 84 days in custody, and within 90 days, this CS has already been submitted.
No.
So, that default bail prayer you cannot pay at this stage. And the case diary, we had called for the case diary, but since the search sheet has already been filed, approach this court. You can very well approach this court. This court. Okay.
Lordship, in this case, Lordship, I am in custody since 80 days, Lordship.
Okay, yes, Botakur.
Lordship. It is also POXO 4, Lordship.
POXO.
No.
Yes.
80 days I am in custody.
For us, sir, any
CD available, my lord.
Okay.
Yeah, my lord, she refused
for medical examination. Girl is 17 years old and Malad Sida 164 for deciding that. Otherwise, Malad. She voluntarily refused to the
go for medical.
Medical. And only because of the video photography, he has that problem. Otherwise, he made the video viral. Otherwise, Malad, though POXO,
I am 80 days in custody, Lordship.
Type of POXO.
Yes, Malad. Below 16, otherwise, so on length of detention, otherwise, Malad, materials are there. 80 days.
Hard Mr. MI done in constitutional petition and also hard Mr. KK Prasha done in additional PP appealing on constitutional response. An application students cities. There is a hard submitted to Mr. Hussain this petition and if an petition was allowed and has not completed the performance as a more so he is behind the birth since last 80 days.
Yes, 80 days.
80 days.
And considering his back, he may be arrested. Whose committed contact, Mr. Parasha, direct submitted that from the TV, it reveals that the girl refused to go for medical examination. And considering the matters in the epileptic case diary, after getting the submission made by the management for the parties, both the parties, I have also filed the case diary and especially the statement of the victim recorded on the constitution. Considering the victim is available in the case and length of detention already undergone by the expedition, I find further custody interrogation is not necessary. Yes. I find it a bit easy to allow the police to go on again.
Special Judge POXO Kamrup M. Lord.
Special Judge POXO Kamrup M. Okay.
Highly obliged.
Did he not receive in this matter?
My Lord, in this case, he has been arrested on 9/6 and today it is 36 days and mandatory period in this case, my Lord, 60 days. So, considering this, my Lord, aspect, if your Lordship wishes to hear this case.
Yes, it's okay, but the case is most probably registered under section
406,
420, even 468 and 471.
Sections are there, numerous sections are there. But the thing is that, my Lord, the amount which has been alleged in this case that misappropriated or being defrauded to the informant, that is, my Lord, a mutual understanding was there and payment already been done. But
is these things will be available in the case diary?
No, my Lord, the case diary is not available.
No.
My Lord.
Whether if it is supposed to compromise the matter, all the money which has been defrauded has already been returned.
My Lord.
Those materials will be available in the case diary as per you.
My Lord,
no, we have not received the case diary.
Yes,
I'm just asking you.
Yes.
Then it may be easier.
In my humble submission, as per instruction that money has the amount already been delivered and something maybe remain to be paid, but the informant has given this huge amount that it is unpaid. But this is not a fact that whether 71 lakhs has been taken or not. This is also disputed facts. So some business relation.
It is short date.
Short date, my Lord.
Short date.
Reminder.
Lord.
Thanks.
Earlier, Your Honor, kindly candidate may be 22, 22nd, if it is possible, because my lord, 22nd, obliged, my lord.
Madam, 439 bail application, but case diary was called for, madam.
CD received not.
CD received? Yes.
But FIR is at page number 11, madam. The basic allegation against me is that, madam, I have executed an agreement with the informant for sale of my plot of land, my lord, measuring 6 lessa, my lord, for a consideration of rupees 19,50,000, my lord. And my lord, I took an amount of 17,50,000 as an advance, my lord. Then, my lord, later on, my lord, I did not transfer the land in the name of the informant and demanded, my lord, additional amount. And also, my lord, I engaged the other co-accused to threaten the informant, madam. That is the basic allegation against.
Detained?
To threaten, to intimidate,
threaten.
intimidate the informant, my lord. That is the allegation, my lord. My lord, my case is that, my lord, I am the landlord, my lord, and the informant and her family is my tenant, my lord.
Your tenant?
Tenant. They are residing in my house as tenant, my lord. For about last 8 months, my lord. My lord, what happened, my lord? I took an amount of rupees 5 lakh from my lord, husband of the informant, my lord, as loan, my lord. And at that time, my lord, the husband of the informant took my signature on some blank papers along with some stamp paper, my lord, which were not written, my lord, or blank condition, my lord. Subsequently, my lord, by using those signatures, my lord, the husband of the informant make some agreement, my lord, that I sold that plot of land where they are residing as a tenant, my lord, to them, my lord. In this regard, I also filed an FIR on the same day, my lord, page number 22, my lord. Page number 22. On the same date, the FIR is filed, my lord. On the basis of my FIR, my lord, the husband of the informant was arrested, my lord. The forwarding report is, my lord, may kindly peruse, my lord, page number 30, my lord. Page number 30. I will read over, my lord, relevant part, my lord, that from the ground of arrest, my lord. Page number 31 may kindly be seen, my lord. Page number 31. This is the arrest memo of the husband of the informant, my lord. Kindly see the ground number 2. May I read, my lord? During preliminary inquiry, it is learned that some circumstances evidence found that he had forged the documents by copying signature of the complainant with an intention to sell a plot of land which the petitioner, or some word is missing, that people possessed, my lord. So, my lord, during inquiry, my lord, it was found that, my lord, he has forged my signature, my lord, to make an agreement, my lord. So, my lord, I am in custody, my lord, for last 36 days, my lord. Allegations and counter allegations are there, my lord. Dispute is between two parties, my lord, tenant and landlord, my lord. All further custodial intervention, my lord, may kindly be not required, my lord. That's my humble submission.
Lordship, here in this matter, what my learned friend has stated that yes, he is a tenant, but there is a kind of transaction between them. And from the witness, it is the 161 with statement of a witness, it reveals that they were taken to that particular portion of that is the rooms where those were rented. Whenever he was failed to give them make the registration, sale deed of the particular plot of land for which he has taken the money. But as per this, another cross affair is also there. That is the statement, and it is filed by the wife of the that is the Bharat Das, was the accused in another matter. And as per the investigation, they are the known person, they are the bosom friend. But there is transaction regarding that party. As per that, there is a transaction between them, and independent witnesses are there. They also stated that.
But yes, but as per the petitioner, most probably, the transaction he did not deny. There was a transaction.
Yes.
But transaction was a kind of loan, and it
Not loan is in his part. Lordship may kindly see two statements of it. Like statement of the complainant and one of the witness.
Further custody may not be required. Transaction I have not denied, my lord. And also, my lord, at the same time, my lord, investigation also says that, my lord, the informant side has also tempered the document, my lord. So, my lord, further custody may not be required. Sufficiently, my lord, 36 days, my lord. Yes.
that for the subject that informant and both sides are at the time. And fact that fact that problem has been blank attempted and member, the wife of not right. Okay. The husband of the woman okay. Was registered. Your case is registered as
Sadgaon PS case number 90/2024.
Sadgaon PS case number 91/24.
Oh, that.
Yes.
Sadgaon
Case number
PS?
23.
Yes.
Sadgaon PS 91 of
91 of 24.
23.
24, my lord.
24.
24. And from the ground of the arrest, sir, see that during investigation it has come. It has come out that the forged signature of the representative in preparing to make plan. Already submitted that it and want to make time that was the one and also fact that the woman and her husband died out of death. But the advocate in the name of the as I was thank for just for it is very
My lord.
cases of pending in Satgaon in Kamrup Metro.
My lord. Kamrup Metro, my lord. CGM Kamrup. Oh, my lord.
Well, both the cases, well, my 11 and my senior counsel, my lord, he is 54, arising from the same police case. In this case, my lord, the fact is this, my lord, the search sheet has been filed. So all the petitioners languishing more than 111 days. And they approached before the session judge for bail, that was rejected on the ground that the search sheet has been filed. So my lord, thing is that, my lord, when the search sheet is filed, it is more easier to grant the bail as per the Supreme Court's two decisions I will rely. So where my lord, Lordship has the ample power to grant the bail because of the three grounds, my lord. One is whether investigation is already completed, nothing to be, my lord, recovered more. Second thing, my lord, there is no any possibility time that when the trial will start. And fourth one is, my lord, there is no chance of any tampering or hampering in the investigation or tampering in the witness, my lord. So on the three conditions, my lord, I rely to, my lord, three judgment, my lord. And so far, my lord, referring the matter, once, my lord, it is a procedure there. Once the search sheet is filed, the trial court only decide this thing. This is, my lord, this is not a, my lord, mandatory. This is only directive, my lord. This is Supreme Court also hold in the serious fraud case. And the another case, my lord, I also relied. At the time of grant, when considering the bail, the fraud, serious fraud case, it is Supreme Court held that the seriousness of the fact need not be considered for rejecting the bail at this stage when the charge has been filed. Considering the
These are not visible.
my lord, it is para in serious fraud case, my lord. Para kindly
Change the this thing. It's not legible.
my lord.
It's a not legible copy.
But this is I download my lord now just now.
What to
Copy
do?
is
It's not,
same, my
it
lord.
cannot be
The
read.
lordship can take my copy, my lord. This is little better.
One can be read at the Supreme Court judgment.
This is one.
Cannot.
This is para 28, 30 and 31 in that case.
Which case?
This is for serious fraud case, my lord. No, this is my lord, this one.
Serious fraud?
No, serious fraud case, my lord, this is 30. Para 30, my lord. Para 30. It is held that if it is well settled that while the lying down a particular procedure is not negative or adverse, consequently are contemplated in non-adhering to such procedure, the relevant provision is more normally not taken to be mandatory and is considered to be purely directory. Further, the provision has to be seen in the context in where it is occurs in the statute. There is a three basic features which are present in the matter, my lord. This is three features, my lord, was given that this is a case, my lord, where, my lord, some, my lord, fraud was, my lord, occurred a serious amount was involved, a huge amount. So that was, my lord, by the authority concerned, the serious fraud. And the second one, my lord, where I rely, it is specifically Supreme Court held and Supreme Court itself granted bail to the, my lord, para, it is also, my lord, 30. It is, my lord, the case second one. This is Sanjay's son versus, my lord, CBI. In that case also, my lord, the para 30 is very specific, my lord, where the circuit was filed the same case. So Supreme Court says that Supreme Court itself granted bail, my lord. So my prayer is, my lord, the same circumstances in my case also. They are I am for the, my lord, driver and the, my lord, the owner in my petition 11, and my learned friend, my lord, the other for the other accused, my lord. So this is the one reason, my lord, I prayed. And the second, my lord, my petition number 1, his wife is, my lord, suffering from serious ailment and is immediately required to be operated. For this, my lord, I have annexed 2 copies of the doctors. So she is required to be operated immediately. So annex of 5 and 6, I have the 2 documents annex in my petition. So considering all these things, and the other petition number 2 is a driver. So he has nothing to do anything, my lord, in this case. And reason the Supreme Court held that they not to keep the behind the bar for a long time, because there is every possibility they may come out with all, my lord, the acquittal or the all without any benefit of doubt. So if it is pre-trial, well, conviction is treated as a pre-trial conviction. So when the trial will start, it is nothing is sure. Nobody can say that when this trial will start. So on that, my lord, I rely to judgment, my lord, lordship has ample power to grant the bail, my lord. This is my prayer, my lord.
My lord, while I am endorsing all the submissions of my learned friend, one additional point is there. Earlier we approached this Honorable High Court. Yes, that is kindly say this Honorable High Court directed us to surrender before the court below and seek bail. That is page 25. That is page 25. And thereafter, my lord, we sought bail before the learned court below. Kindly see page 25. Hearing the submission made by the learned counsel for both sides, and also considering that the case has already been charge sheeted. The petition is hereby directed to appear before the learned court below with appropriate application for bail, which may be considered in accordance with law. Thereafter, we surrendered and we filed petition, that is page 26. But the learned trial court rejected the bail prayer. That is why this is the second bail application. Now our submission is this 111 days. And my lord, one important thing is here, Lordship would see, police has hurriedly filed the charge sheet only to see us behind the bar. Kindly see page 22A. Page 22A, second line may be seen. Due to shortage of time of investigation, so after discussion about this case with the senior officers and well established this case under section 365-392, IPC by the evidence and witnesses filed this charge sheet. So there is no shortage of time. Actually, they wanted that to see us in behind the bar beyond 90 days. So we are behind the bar since 111 days, and there is no certainty when the trial would start. So, my lord, we have suffered heavily, man. And so far the mandatory period is only 90 days. Of course, after charge sheet that does not arise, but even then 111 days is not a lesser days. So, my lord, we will cooperate. Under any condition, you may kindly be granted bail. We have carried out Lordship direction. Your Lordship directed us to surrender. We have surrendered. But rejected, so we have come.
My lord, in this Sanjay case itself, when the Supreme Court given the direction, they put all the condition, my lord. Yes. Lordship will see, my lord, the last part. The Supreme Court itself put the condition under which will they will be this. So Lordship will.
Those are their Lordship is ever about this. It is not the motto that for an indefinite period a person should be kept behind the bar.
Okay, every possibility they might be released, my lord. This is the thing. So that can be proved that they will always be convicted. Whatever they have suffered more.
111 days. Long time.
Dear Lordship, cognizance of the offence has already been taken on 17/5/24. Cognizance has been taken against Lordship this petitioner Alimuddin and Majed Ali. 365 and 392 has been taken, Lordship. And against the other two petitioners in item number 54, that is Jiarul Islam and Yasin Mullah, 412 IPC.
So I am those two persons.
Yes.
412.
If Lordship kindly takes up the IPC, Lordship, the provisions of the sections, Lordship, for a minute, Lordship, 392 is Lordship.
392 is Dakati.
Lordship is well aware, Lordship, of the 392 punishment for robbery, Lordship. That is, Lordship, the explanation 2 will come into effect, Lordship. Whoever commits robbery shall be punished with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. And if the robbery is committed on the highway between sunset and sunrise, the imprisonment may extend to 14 years, Lordship. That is apparently, Lordship. And here, Lordship, the offence was committed on a highway and late at night, Lordship. That is also there. And regarding, Lordship, 412, Lordship, section 412, that is also quite serious, Lordship. Dishonestly receiving property stolen in the commission of a dacoity. That is, Lordship, whoever dishonestly received or returned, I will not go into the details, Lordship, shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. That is there, Lordship.
Dacoity is not yet proved.
Ingredients is not there, my lord.
The ingredients are not there.
Where is the force, my lord?
And moreover, considering the period of detention, the Lordship may kindly consider.
Section will not say anything. The section description is there. But whether the offence is committed in that way or not, this is the thing. The allegation is that unloaded and loaded. And that two persons were brought and they were dropped. So this is the allegation. The only basis of that allegation, whether that can be 392 is done.
392, my lord, weapons, they are just be serious, grievous hurt, nothing is there. Only putting section is not enough.
Section is not enough.
So now, Lordship, another thing is, Lordship, since they are insisting on whether the materials are available or not, Lordship, in that regard, Lordship, the LCR, I have gone to the LCR, Lordship, in the last occasion, the case diary was also called for, scan copy. It is not complete, Lordship.
It has come today.
Entire CD is not there, Lordship. Only the statement of the informant and one or two witnesses are there.
No,
other
witnesses,
materials are not there, Lordship.
perhaps witnesses are not yet examined, my lord.
No, of the case diary of the CD, Lord. That's what
My
I'm
lord,
saying.
kindly consider the period of detention and nature of the
Lordship,
charge side. What
after
more?
charge sheet, Lordship, after charge sheet is laid, bail has to be considered on the materials gathered during the investigation, Lordship. And for that, Lordship, the CD has to be perused. What kind of materials has been investigated, Lordship? That is not apparent from the case diary, Lordship.
That is why we have given 3 judgments of the Honorable Apex Court.
Oh, Baba. Supreme Court judgment cannot.
If you do not believe the Apex Court judgment,
CD
then
is on the basis of CD search has been filed.
Lordship, either let them
so
finish,
many judgments are there. my
Lordship, they are interrupting all the time, Lordship. I cannot finish that way, Lordship. Either let them finish or let me start, Lordship. Lordship, the investigation was done, materials were collected, that is in the case diary. CD was called for. CD is not complete, Lordship. The materials, entire materials are not before your Lordship. Now, this is a case where charge sheet has been laid. So, bail has to be considered after perusal of the materials that has been collected against the petitioners, Lordship. That is my submission, Lordship. And regarding the offence, Lordship, Lordship has already seen the provision, Lordship. 14 years, life imprisonment. This is serious offences, Lordship. So, bail cannot be given as a matter of right, Lordship, because charge sheet has already been submitted. And so far, regarding the whether the trial is progressing at a rapid pace or not, Lordship, I have already stated the cognizance has already been taken. And next date, Lordship, was fixed on 12/7/24. That is not apparent, Lordship, what happened on that, Lordship. The next last date was fixed on 12/7/24. That is my submission, Lordship. And there are various judgments of Supreme Court also, Lordship, that only the length of detention is not the paramount consideration, Lordship. There are other factors also that has to be considered, Lordship, like the severity of the crime, chances of responding, tempering of evidence, all that has to be taken into consideration, Lordship, by your Lordship. So, Lordship will kindly go to the case diary, see the seriousness of the offence. After that, Lordship can pass any order.
My Lord may kindly see, my Lord may kindly see order dated 27/6/24. On that day, scan copy was called for because case was charge sheeted. So scan copy was called for, and today it has come. Now today my learned friend is saying about CD. CD will say nothing new thing. Scan copy and CD are the reflection of each other. So my submission is only this, my lord. Yes, only detention is not
he
enough.
is not on that. He is saying that we have received the scan copy of the case record along with the case diary. He is saying the case diary is not complete because there are some statements are not available. That's what.
My lord, case diary is not complete, should not be believed because charge sheet is already filed.
No. Why scanning or why doing this?
Yes, that is the.
That may be there. Otherwise.
But even then, my lord, 111 days is not a minor matter, my lord. And moreover, 392, 90 days mandatory period. Hurriedly charge sheet has been filed to avoid time, so that they may be kept behind the bar. That is not the motto. That is not the motto of law. Law says that a person should not be kept unnecessarily. Now, whether necessary or unnecessary, that is subject to the trial. Subject to trial, but it may take years together. Lordship is aware about the things going on nowadays in trial courts. So, my lord, considering the detention, considering the filing of charges, considering that they cannot hamper it or tamper in the investigation under any condition, considering detention, that is one of the considerations. Detention is one, my learned friend said that is not the sole consideration, but it is one of the considerations. Kindly.
Yes. Pass the order.
My lord, one thing, my lord, in my case, my lord, annexer 4, Lordship has a look, my lord, on this.
Your
Well,
wife,
yes, my lord, yes, my lord, this is session judge has, my lord, rejected on the ground that the search sheet has been filed. So, my lord, my submission is, my lord, if the investigation is not completed, CD is not complete, how search sheet has been filed, my lord? Charge is on the basis of the
No. You have misunderstood. I think he is not on that point. He is saying this investigation is completed, charge sheet has been filed.
Yes.
He is saying that the copy which we have received, here, while scanning all those pages, there most probably some pages are not there, where in the statement of the witnesses were.
That may be my lord.
Then my landed friend could have said on the last occasion also, but
on
last
that ground,
occasion my landed friend was keeping mum.
But on that ground, my lord, the copy, they could not brought this scan copy serially properly. This is not the ground, my lord. They object. They are not able to bring this thing. My submission is this, my lord. I rely to two judgment, my lord. It is ample power is given to the High Court because that same principle was followed by the Supreme Court in two cases, my lord. So my humble sum, my lord, is considering the all long detention, they will be granted. Yes, I have only question.
Lordship, item number 59 and 60, Lordship. Take the two more, Lordship.
Lordship will pass the order, my lord.
I'll pass the order.
Right.